I've got an itch I can't scratch, I'm missing a piece that completes a whole part of me, an open wound scar to see. Everybody come here, gather round, welcome to the freak show, the best in town. What the hell's wrong with me? I don't get along with anybody, honestly. I've been living in my own head constantly, thoughts jumbled round, think I need a new lobotomy. Wait, all these thoughts are too negative. I don't wanna get lost in the sedative. Gotta show them what I got, I'm competitive. You know I'm about to go off, I won't let them win, I'll take a stab. I wanna chase a bag, I wanna weigh, I can change all the things I lack. I gotta face the facts, I got a taste in that. Got me obsessed with the rest, I got an itch to scratch. I'll give up everything.
Good morning, ladies and gentlemen.
Good morning.
We continue with the state case.
Yes, Your Honor, good morning. State recalls Kristen Maydell.
She types loud.
And you are still under oath, Ms. Maydell. You may be seated.
Good morning.
Good morning. Excuse me. Sure, it's Kristen, Aristen, Maydell, Madel.
Welcome back.
Thanks.
Ms. Maydell, just before we get started, I'm going to hand you some exhibits which have been pre-marked for identification purposes. Specifically, I'm going to be handing you state's exhibits 19 through 26, as well as 29 for identification. And I'm also going to be handing you states 112 for identification and 117 through 121 for identification purposes. Ms. Maydell, are those all reports that you authored in connection with this case?
Yes.
Now, you were with us last time discussing certain DNA results from evidence recovered from 69 Wells Lane, a 2014 Range Rover and a 2017 Chevrolet Suburban. Did you conduct an additional analysis in this case?
I did.
And that analysis that you did was on evidence which was submitted to the State Forensic Laboratory in accordance with standard laboratory protocols. Is that correct?
Yes.
Now, prior to receiving some of this evidence, it was actually analyzed by different units of the forensic laboratory, including the latent print unit as well as the forensic biology unit. Is that correct?
Yes.
Now, before we discuss the additional analysis that you did, I'd like to talk to you now about nuclear DNA and mitochondrial DNA. To begin with, what is nuclear DNA?
Nuclear DNA is DNA that's unique to an individual. It's found in the nucleus part of the cell. If you think of it as like an egg, the yellow part of an egg would be where the nucleus is, and your DNA, nuclear DNA is located there. You get half your nuclear DNA from your mother, half your nuclear DNA from your father.
And conversely, what is mitochondrial DNA?
Well, mitochondrial DNA is also found in the cell, but it's found in the white part of the cell. It's found in the mitochondrial organelles that are in the white part of the cell. I think previously I misspoke in my old testimony, first testimony, that mitochondrial DNA is on the X chromosome, which it's not. It's found in the mitochondrial. And this type of DNA is inherited maternally. So you get this DNA from your mother. So my mother has the same mitochondrial DNA as myself, and I pass that same mitochondrial DNA on to my children. So this is not unique to an individual.
What are the differences between nuclear DNA and mitochondrial DNA in terms of its ability to discriminate between individuals?
So nuclear DNA is unique to an individual besides identical twins, whereas mitochondrial DNA is not, because you have it in the same maternal line.
The last time you were here, we discussed nuclear DNA results. Is that correct?
That is correct, yes.
But you also did mitochondrial DNA testing in this case.
I did, yes.
And the analysis that we're going to discuss today actually addresses both of those different types of analysis, depending on which item you looked at, correct?
Correct, yes.
I wanted to talk to you about the basics of DNA, specifically what types of things can destroy DNA or contaminate DNA potentially. Can water destroy DNA on a surface or make it harder to detect?
It can wash it away. Bleach is known to destroy DNA, UV light, but water can wash DNA away if it's poured on top of where DNA may have been left.
Can shampoo destroy DNA or make it harder to detect?
It's possible. Again, it would do the same effect as just water washing it away or getting rid of the DNA that may have been there.
Can wiping a surface either destroy or remove DNA?
Yes, again, it's possible. If you have a spill on the counter from juice or something and you wipe it away on to that paper towel, it goes onto the paper towel. So same thing can happen. If you wipe a surface with DNA, it could get onto the paper towel and then you could remove it.
How about vacuuming an area?
Same concept. Yep, you could possibly remove it from the surface.
Does the amount of time that DNA is on an object also influence whether or not it can be detected by your equipment?
Yes, of course. If it's there, if you leave DNA and then try and swab it and detect it right away, you might have a better result than if you wait a week or two.
Why is that?
Because it could get wiped away, it could degrade from the environment, you just would lose that DNA.
Now, when a DNA profile is developed, is it possible to tell whether or not the profile came from blood, saliva, skin cells, or any other source?
No, we cannot say that.
And just to refresh the jury's memory, you spoke with us last time about STR-mix. What is that?
STR-mix is the software that is used to help the DNA analyst interpret that DNA profile and give a statistical calculation to the weight of that evidence.
Now, I want to direct your attention to 2019 and the initial analysis that you conducted in this case. What DNA kit was the laboratory using at that point?
We were using for amplification, we're using a Fusion 6C amplification kit.
And What DNA kit does the laboratory use now?
Currently, we use the Global Filer STR amplification kit, which is just a different company.
What are the differences between the two kits?
The two kits have a couple of different sites that the Fusion had a few more sites that the Global Filer kit does not have.
And so how can that influence or impact the DNA analysis?
So since all the evidence was processed with that Fusion 6C kit originally, most of it, some subsequent testing was done with Global Filer and evidence, but the original evidence that was done in 2019, 2020 was done with the Fusion kits, which had 27 sites and 23 of them were used to perform statistical analysis if you had a match. Currently, the Global Filer kit has 24 sites with only 21 sites being used for statistics. So if you compare a new known that was done with the new kit, Global Filer, and only has 21 sites to use to compare to the original Fusion kit, you can only use those 21 sites. So therefore, those two sites that you had information and the evidence are not used for the statistical calculation.
Now, did you receive two separate known DNA samples from the defendant, Michelle Troconis, in this case?
I did, yes.
And the first one was received in 2019,
Yes,
and the second one was received in 2023, correct?
that is correct, yes.
And so did you generate a profile from the known DNA samples in both instances?
I did, yes.
And did you do an analysis of the second known profile against the evidence that had already been tested?
Yes, I wrote reports for the first comparisons when I compared her first known to all the evidence. And then in 2023, when her known was reprocessed with the new kit, I then went back and compared the new results of that known to all the previously done evidence.
Now, the new kit that you referred to is called what?
Global Filer?
And Global Filer has less testing sites than Fusion 6 did.
Yes.
Now, in addition to the two known samples that you received from the defendant, can you just refresh the jury's memory as to who else you received known samples from?
I received known samples from Otis Doulos, Lauren Almeida, the swabbing of the electric toothbrush uses a pseudo-known, Pavel Bumeni, and the 5 Doulos children.
Now, I'd like to direct your attention now to some of the specific analysis that you did and some of the results. Judge, if I may just have permission again to use my computer and be seated for the examination.
Yeah.
And I'm just going to begin by publishing the stipulation again, Your Honor. Paragraph 10 of State's Exhibit 103. State Police Exhibit 502K, seized from Hartford by Sergeant Kevin Duggan on May 31st, 2019, and identified as 4 pieces of black plastic garbage bag with duct tape attached to 2 pieces contained within State Police Exhibit 502, seized from the scene, corner of Albany Avenue and Green Street, Hartford, Connecticut, was subsequently submitted to the Division of Scientific Services and designated as Submission 88. And Your Honor, I'm going to open up and display to the jury State Trial Exhibit 111A. Specifically a folder entitled State Police Exhibit 502K, Lab Submission 88. And there's a subfolder 88-3, which I'm opening. And I'm going to display the photograph 88-3S7. And Ms. Maydell, just for your benefit, I believe this is encompassed in DNA supplemental reports 4, 9, and 18. Excuse me. I apologize, 5, 10, and 18.
Okay.
So I'd like to discuss with you now, there was a swabbing which was done by Ms. Troconis, identified as 883S7. Did you have an opportunity to do a DNA analysis on that particular swabbing?
Yes, I did.
And what were the results?
The results are consistent with the DNA profile from item 883S7 being a mixture of 4 contributors, with at least 2 of them being male. Assuming 4 contributors, the DNA profile from 883S7 is at least 100 billion times more likely to occur if it originated from the source of the DNA profile from the swabbing of the electric toothbrush and 3 unknown individuals than if it originated from 4 unknown individuals. In assuming 4 contributors, the DNA profile from 883S7 is at least 100 billion times more likely to occur if it originated from Foetus doulos and 3 unknown individuals than if it originated from 4 unknown individuals. Assuming 4 contributors, the DNA profile from item 883S7 is at least 780,000 times more likely to occur if it originated from Michelle Troconis and 3 unknown individuals than if it originated from 4 unknown individuals.
And did you also have an opportunity you indicated that you received 2 separate knowns from the defendant,
Yes,
and you, I guess, reanalyzed the evidence using the second known with the second kit. Is that correct?
the original evidence was not reanalyzed, but the comparison was done to the new known, which had 2 less sites.
Okay.
Yes.
And what were the results for that particular analysis with respect to the defendant?
Assuming 4 contributors, the Fusion 6C DNA profile from item 883S7 is at least 250,000 times more likely to occur if it originated from Michelle Troconis and 3 unknown individuals than if it originated from 4 unknown individuals.
So I'd like to talk to you now about the differences in those 2 stats. In the first analysis that you did, it was 780,000 times more likely, and in the second, 250,000 times more likely. Can you explain how that's possible, and is that first stat still valid?
Both stats are valid. It's just, as I said before, when we switched to this new kit with the new known that was submitted last year, 2023, it had 2 less testing sites to use for statistical calculations. So therefore, when I compared the new known to the original evidence that had more data, I can't use those 2 sites because I don't have data from the known. So when you do the statistical calculation, you're losing those 2 sites when you're doing basically the product rule. So if you have 2 times 2 times 2, 21 times, 2 times 2 versus 23 times, you're obviously going to have a higher number with those 2 extra times that you're multiplying the numbers out.
And did you also do an analysis as to the doulos children, as well as Lauren Almeida and Pavel Gumieni?
Yes, I did.
And that's found in DNA supplemental report number 10 for your benefit. What were the results of that?
First, Lauren Almeida and Pavel Gumieni were both eliminated as possible contributors to that 4-person mixture. When comparing all 5 children, they were all at least 100 billion times more likely to occur if they originated from individually each of those children and 3 unknown individuals than if it originated from 4 unknown individuals.
So Ms. Maydell, does that mean that the children touched this bag, or that it is in fact the children's DNA?
I can't say who touched the bag for any of these conclusions. All I can say is looking at this 4-person mixture, it appears that the 2 major contributors that are contributing to this 4-person mixture are contributing about the same amount. So approximately the same amount from both of those 2 major contributors. And if those 2 major contributors are the parents of these children, you get half your DNA from your mother and half your DNA from your father. So if your parents' DNA is all there, of course, you're going to have your profile be there, your types be there, because both your parents are contributing to that profile.
I'd like to talk to you about the remainder of the 88-3 DNA results, if I could, specifically beginning with 88-3S1. And for the remainder of these, Ms. Maydell, those will be found in supplemental reports 4, 9, and 18 for your benefit. So
Okay.
beginning with 88-3S1, which was identified as a swabbing of a knot area by Ms. Valonis, what were the results?
The results are consistent with the DNA profile from 88-3S1 being a mixture of 2 contributors. Assuming 2 contributors, the DNA profile from item 88-3S1 is at least 26,000 times more likely to occur if it originated from the source of the DNA profile from the swabbing of the electric toothbrush and 1 unknown individual than if it originated from 2 unknown individuals. Assuming 2 contributors, given the low likelihood ratios calculated, the results are inconclusive as to whether photostaulos could be a contributor to the DNA profile from item 88-3S1. And Michelle Troconis is eliminated as a contributor to the DNA profile from item 88-3S1.
And we're in supplemental number 9, were Lauren Almeida and Pavel Gumieni eliminated as well?
Yes, that is correct. They were both eliminated.
And with respect to the children, what were the results?
Sorry, which report is that?
DNA supplemental report number 9.
Oh, that's also 9. All 5 children had low likelihood ratios calculated, so they are inconclusive as to whether they can be contributors to this profile, 88-3S1.
And since it's displayed in the photograph, I wanted to jump ahead to 88-3S5. Which was identified as a hair-like fiber in the knot of the bag. You performed mitochondrial DNA analysis on this. I believe it can be found in your report, DNA supplemental report number 12.
Yes.
And can you just indicate to the jury what the results were?
So for this hair, I attempted to get nuclear DNA from the hair, and I was not successful. There was no nuclear DNA detected. So because of that, we then went to the hair shaft and tried to get mitochondrial DNA profile from that hair. So which I did obtain a full mitochondrial DNA profile from 88-3S5. So the mitochondrial DNA sequence from 88-3S5 and 7G1 are the same. Therefore, the source of the DNA profile from the swabbing of the electric toothbrush cannot be excluded as a source of 88-3S5. I feel like I should explain that conclusion a little bit more because I don't think we talked about how mitochondrial DNA conclusions are different than nuclear.
Sure.
Since it's not unique to an individual and it's through the same maternal line, we say if 2 profiles match in the mitochondrial, that they can't be excluded as coming from the same source or anybody in that maternal line. So a little bit different for mitochondrial DNA sequencing versus looking at those repeats that I talked about last time. We were looking at, say, 4 letters, A, G, T, T, repeated 9, 10 times. That gives you your type. For mitochondrial DNA, you're looking at the actual order of those bases. So say you have the letter CAT, that spells cat. If you rearrange those letters and you do ACT, that is act. So those two do not match. They're 2 different profiles. So that's mitochondrial DNA. That's what we're actually looking at, is the order of the bases to see if they match. And then we say, if they do match, they cannot be excluded. And then we search the database of all these profiles to see how common or rare that profile is. It's a more of a frequency estimate versus a likelihood ratio. So after I made the conclusion that 883S5 and the profile from 7G1, the toothbrush, are a match, I then searched the database to see how common or rare that sequence is. We typically report the 3 major ethnic groups in Connecticut unless there's a match within another ethnic group, and then we report all statistics. So I'll read those now. So in the African American population, I wouldn't expect to see this profile in more than 0.32% of the population. In the Caucasian population, 1.33% of the population. Hispanic, 0.42% of the population. Asian, 0.46% of the population. And Native American, 0.62% of the population. Now, in comparing that profile from 883S5 to the mitochondrial DNA profile from Fotis Dulos, Michelle Troconis, Lauren Almeida, and Pavel Gumeni, they're all excluded as being a possible match source of that profile from the hair. I could also explain that we didn't test the children's mitochondrial DNA because it was irrelevant, because we have the mitochondrial DNA profile from the toothbrush, and it would have been the same.
Yeah, and speaking of the toothbrush, just to refresh the jury's memory, you did a parental analysis on the toothbrush to determine the likelihood that the profile on the toothbrush was related to Petros Dulos. Is that correct?
Correct. I made a maternity-paternity stat to the toothbrush to one of the children to show, yes.
And I don't want to misquote, but I think it was something like 8 billion times more likely to be the mother of Petros Dulos.
It was something around that, yes. I don't know if I have that report here with me.
I believe it's DNA Supplemental Report 16.
16, let's see. Yes. Yes, the expected frequency of individuals who could be the parent of Petros Dulos is less than 1 in 8.1 billion people in the general population.
I wanted to go back to 883S7 for a second, if I could. This was the result in which you concluded that the defendant was 780,000 times more likely to be a contributor, or 250,000 times more likely to be a contributor, depending on which kit you used. And I know you indicated that you can't tell us how DNA got onto a particular object. Is that correct?
That is correct, yes.
But I want you to assume the following facts are true. I want you to assume that the defendant in her 3rd interview with police indicated to them that she held a bag open for Mr. Dulos as he deposited something in the bag. Is it possible that her DNA could have gotten on the bag as she was holding it?
Yes, that's possible. We know that if you come in contact with something, it is possible for you to leave your own DNA behind on an item.
Now I'm going to display in this folder, which is State Police Exhibit 502K Lab Submission 88, subfolder 883. There was additional swabbing, specifically 883S2 and 883S3. 883S2 was identified as a reddish-brown staining on the exterior, and 883S3 was identified as a reddish-brown staining on the exterior. Both approximate areas of swabbing displayed in this particular photograph. What were the results for these two particular swabs? And this can be found in DNA reports 4, 9, and 18.
Eighty-eight 3S2, the results are consistent with the DNA profile from item 88 3S2 originating from a single female individual. Assuming one individual, the DNA profile from item 88 3S2 is at least 100 billion times more likely to occur if it originated from the source of the DNA profile from the swabbing of the electric toothbrush than if it originated from one unknown individual.
And were all other known profiles eliminated?
Yes, all of the known profiles eliminated.
And then with respect to 88 3S3, the reddish brown staining on the exterior, was that the same result?
That is not number 4. So 88 3S3.
Yes.
Yes, same results, single female individual. Yes,
Okay, so 100 billion times more likely to originate from the profile generated from the toothbrush, and all other known individuals were eliminated?
correct, yes.
And then on this same item, 88 3S4, I'm displaying that photograph, lab 88.3S4, and this was identified as exposed sticky sides of duct tape.
The results are consistent with the DNA profile from 88 3S4 being a mixture of 2 contributors. Assuming 2 contributors, the DNA profile from item 88 3S4 is at least 100 billion times more likely to occur if it originated from the source of the DNA profile from the swabbing of the electric toothbrush and one unknown individual than if it came from 2 unknown individuals. Fotis Doulos and Michelle Troconis are eliminated as contributors to item 88 3S4.
And as were all other known individuals, is that correct?
That is correct. Lauren Almeida, Paul Gumeni, and all 5 children were eliminated.
And I'm going to go to state trial exhibit 109 now. And I'm going to open a folder entitled State Police Exhibit 502U, Lab Submission 41. And I'm going to publish paragraph 12 of that same stipulation. State Police Exhibit 502U, seized from Hart by Sergeant Kevin Duggan on May 31st, 2019, and identified as one black plastic garbage bag tied in a knot containing a shirt and bra with blood-like substance contained within State Police Exhibit 502, seized from the scene, corner of Albany Avenue and Green Street, Hartford, Connecticut, was subsequently submitted to the Division of Scientific Services and designated as submission 41. So I'm opening State Trial Exhibit 109 folders, State Police Exhibit 502U, Lab Submission 41. And Ms. Maydell, for your benefit, this can be found in your very first DNA report, as well as supplemental reports 1, 9, and 18. And I'm displaying the photograph, lab 41.1 exterior front.
So you said 41 1S1.
Correct. That is identified as a portion of a reddish brown stain from the shirt. What were the results?
So in the first report, it was only compared to the swabbing of the electric toothbrush. The results are consistent with the DNA profile from item 41, 1S1 being a mixture of 2 contributors. Assuming 2 contributors, the DNA profile from item 41, 1S1 is at least 100 billion times more likely to occur if it originated from the source of the DNA profile from the swabbing of the electric toothbrush and one unknown individual than if it originated from 2 unknown individuals.
And then in supplemental reports 1, 9, and 18, would it be fair to say that all other known profiles were eliminated as being contributors to that particular profile?
Yes, that is correct. Everyone else is eliminated.
And I'm going to display a photograph entitled Lab 41.2 exterior front. Excuse me, strike that. I'm going to display Lab 41.2. Specifically 41.2S1, which was identified as a portion of reddish brown stain from bra. And this can be found for your benefit, Ms. Maydell, in supplemental reports 2, 9, and 18. Can you just indicate to the jury what the results were?
The results are consistent with the DNA profile from 41.2S1 being a mixture of 2 contributors. Assuming 2 contributors, the DNA profile from 41-2S1 is at least 100 billion times more likely to occur if it originated from the source of the DNA profile from the swabbing of the electric toothbrush and 1 unknown individual than if it originated from 2 unknown individuals. Fotis Doulos and Michelle Troconis are eliminated as contributors to 41.2S1.
And then with respect to supplemental report number 9, the results were inconclusive as to the Doulos children. Is that correct?
That is correct. And Laura Almeida and Paul Gilmany are also eliminated as contributors.
And just sticking with this particular submission, 41.3. And specifically the swabbing 41.3S2. And this was identified as a swabbing of the knot interior. What were the results? And this is found in 2, 9, and 18.
The results are consistent with the DNA profile from item 41.3S2 being a mixture of 2 contributors. Assuming 2 contributors, the DNA profile from 41.3S2 is at least 100 billion times more likely if it originated from the source of the DNA profile from the swabbing of the electric toothbrush and 1 unknown individual than if it originated from 2 unknown individuals. The results do not support the hypothesis that Fotis Doulos is a contributor to this profile. Assuming 2 contributors, Fotis Doulos is eliminated as a contributor to item 41.3S2. The same conclusion from Michelle Troconis. The results do not support the hypothesis that she's a contributor. Assuming 2 contributors, Michelle Troconis is eliminated as a contributor to 41.3S2.
And with respect to the children, were the results that it was inconclusive as to whether or not they could be contributors to the profile?
That is correct.
And Pavel Gugliani and Lauren Almeida were eliminated.
Yes, the results did not support the hypothesis that they were contributors. They were also eliminated.
And just to refresh the jury's recollection, when you're saying that a result is inconclusive, what exactly does that mean?
That means that when we perform our likelihood ratio statistic, the number generated is above our elimination threshold, but below our threshold to say that it's a positive association. So we say no comparison, no conclusion can be made for that comparison.
I'm going to direct your attention now to 41-3-31S1 or 31S1, identified as a reddish-brown stain on the panty liner found within that particular submission. Did you get any results?
No DNA profile was generated from that sample.
And how about 41-3-1S2, which was a swabbing of the absorbent side of that particular panty liner?
The results are consistent with the DNA profile from item 41-3-1S2, originated from a single individual. Due to the limited data detected from 41-3-1S2, the comparison to the source of the DNA profile from the swabbing of the electric toothbrush is inconclusive. Due to the limited data detected from that same item, the comparison to photostaulos is inconclusive. Michelle Troconis is eliminated as the source of the DNA profile from 41-3-1S2.
And is it also fair to say in DNA supplemental report number 9, you concluded that Lauren Almeida, Pavel Gumieni, Petros Doulos, and Noel Doulos were eliminated as well?
Correct. And due to the limited data detected, the comparison to Constantine, Christiane, and Theodore are also inconclusive.
I want to just read a stipulation, paragraph 13 of State's Exhibit 103. State Police Exhibit 154, seized from Hartford by Sergeant Michael Butin on May 31st, 2019, and identified as one FedEx envelope, color white, containing 2 altered Connecticut license plates, seized from the scene storm drain at 1344 Albany Avenue, Hartford, Connecticut. It was subsequently submitted to the Division of Scientific Services and designated as submission 96. So I'm opening up State Trial Exhibit 109, the folder, State Police Exhibit 154, lab submission 96. And I'm just going to display this. Lab 96, 1S1. These were photographs that it came to your attention that these particular license plates and the FedEx envelope that contained them were in a sewer drain. Is that correct?
Yes, that was in the description, yes.
So I want to just direct your attention to DNA report number 6, supplemental report number 6. Were you able to generate a profile on either of these license plates or the FedEx envelope?
Can you repeat the numbers, please?
It's DNA supplemental report number 6.
Sorry, no, the item numbers.
Oh, I'm sorry.
That's okay.
96, 1, 96, 2, and 96, 3.
No DNA profile was obtained from any of those swabbings.
Okay, so the license plates that were found in the sewer drain did not have any, you were not able to get a profile?
We did not detect any DNA, no.
Could you just indicate to the jury how those items being in a sewer drain could have potentially influenced any DNA evidence that might have been contained on them?
Well, DNA, a sewer probably has water in it, I would believe. So water being exposed to the evidence that was sitting in the sewer drain would possibly wash it away. Also, depending how long it was in the sewer drain makes a big impact on getting rid of DNA also.
I'm going to read a stipulation now, paragraph 2, State Police Exhibit 502A, seized from Hartford by Sergeant Kevin Duggan on May 31st, 2019, and identified as one clear plastic bag with blood-like substance contained within State Police Exhibit 502, seized from the scene, corner of Albany Avenue and Green Street, Hartford, Connecticut, was subsequently submitted to the Division of Scientific Services and designated as submission number 50. And staying within State Trial Exhibit 109, I'm opening up the folder entitled State Police Exhibit 502A, Lab Submission 50. And I'm displaying Lab 50 with paper added. There was a swabbing done here identified as 51S2, a portion of a reddish brown staining on the exterior as received. And the results of this can be found in DNA supplemental reports number 2, 9, and 18.
The results are consistent with the DNA profile from item 51S2 being a mixture of 2 contributors. Assuming 2 contributors, the DNA profile from item 51S2 is at least 100 billion times more likely to occur if it originated from the source of the DNA profile from the swabbing of the electric toothbrush and 1 unknown individual than if it originated from 2 unknown individuals. Fotis Doulos and Michelle Troconis are eliminated as contributors to the DNA profile from 51S2.
And then with respect to the children in DNA supplemental report number 9, is it fair to say that the results were inconclusive as to all Doulos children, whether or not they could be contributors to the profile?
That is correct, and Lauren and Pavel are both eliminated as contributors.
Attorney McGinnis, it may be helpful if the jury does not recall what those items are to indicate what the items are in the photo.
Oh, yes, sir. This is lab submission number 50, which was identified as State Police Exhibit 502A, 1 clear plastic bag with blood-like substance seized from Hartford.
Your Honor, for the record, isn't it blood-like stain is what it refers to rather than substance?
The stipulation that we entered into indicates blood-like substance. And I want to direct your attention now to DNA supplemental report number 12. There were hair-like fibers that were taken from submission number 50 that you did mitochondrial DNA testing on. Is that correct?
That is correct. I tried to do nuclear DNA testing and did not develop a profile, so then we went to mitochondrial DNA testing.
And is it fair to say that everyone was eliminated?
Yes, I developed a full mitochondrial DNA profile and none of the profiles matched to any of the known profiles matched to this evidence.
Just going to read paragraph 3. State Police Exhibit 502B, seized from Hartford by Sergeant Kevin Duggan on May 31st, 2019, and identified as 1 clear plastic bag with blood-like substance contained within State Police Exhibit 502, seized from the scene, corner of Albany Avenue and Green Street, Hartford, Connecticut, was subsequently submitted to the Division of Scientific Services and designated as submission number 51. I'm going to stay within that same disk and open up that folder. And I'm displaying the photograph entitled Lab 51 as received. Now, there were swabbings taken by biology of this as well, beginning with, and these next several results, Ms. Mado, can be found in 2, 9, and 18 for your benefit. Beginning with 51 1S3, which was identified as reddish brown staining of the exterior. Could you indicate to the jury what the results were?
The results are consistent with DNA profile from 51-1S3 originating from a single female individual. Assuming one individual, the DNA profile from 51-S3 is at least 100 billion times more likely to occur if it originated from this source of the DNA profile from the swabbing of the electric toothbrush than if it originated from an unknown individual.
And then is it fair to say that all known profiles that you analyzed were eliminated from this particular sample?
Yes, that is correct.
And 51-1S4, which was identified as a reddish brown staining from the front lower opening. Were the results the same in that it was 100 billion times more likely that the profile generated from the toothbrush was a contributor than an unknown person, and all other individuals were, or all other known individuals were eliminated?
Yes, it was a single female profile.
And 51-1S5, which was identified as a reddish brown stain from the hood top area. Same results?
Yes.
Just going to display the photograph 51-1S6 and 51-1S7. With respect to 51-1S6, was it the same results, 100 billion times more likely to be generated, that profile to be generated from the profile obtained from the toothbrush as opposed to an unknown person, and all other known individuals were eliminated?
Yes.
How about 51-1S7?
Same results.
Now I'm going to display the photograph, lab 51-1S3 and S4 and S5 and S6 and S8. And 51-1S8, what were the results?
Same results.
Okay, and that was identified as a swabbing from the exterior of hood.
Correct.
I don't know that I identified 51-1S6 and 51-1S7, so I'll just do that for the record. 51-S6, for which you received the same results, was identified as a swabbing from the interior of hood. Is that correct?
Yes.
And 51-1S7 was identified as reddish brown staining from the interior front. Is that correct?
Correct.
Okay. I want to jump ahead to also 51-1S2, which was identified as a hard whitish material with reddish brown staining. There was a swabbing done of that as well, which was identified as 51-1S2-2. Is that correct?
51-1S2.
And I think this can be found in DNA report 11 and 19.
Results are consistent with the DNA profile from item 51. Oh, I'm sorry, hold on one second. 51. My report refers to it as 51S2-2.
That's correct.
Okay. The DNA profile from item 51S2-2 originating from a single female individual, assuming one individual, the DNA profile from 51S2-2 is at least 100 billion times more likely to occur if it originated from the source of the DNA profile from the swabbing of the electric toothbrush than if it originated from an unknown individual. And all other knowns are eliminated from that profile.
going to jump ahead to State Trial Exhibit 111A. This was Anita Valonis's disc. And I'm just going to read a stipulation, Your Honor. State Police Exhibit 502C, seized from Hartford by Sergeant Kevin Duggan on May 31st, 2019, and identified as one yellow and green kitchen sponge with blood-like substance contained within State Police Exhibit 502, seized from the scene, corner of Albany Avenue and Green Street, Hartford, Connecticut, was subsequently submitted to the Division of Scientific Services and designated as submission 54. I'm just going to open that folder and display the photograph entitled Lab 54 1S, 54S1 and 54S2. And Ms. Maydell, just for your benefit, all of these results with respect to this particular submission can be found in supplemental reports 3, 9, and 18.
The results are consistent with the DNA profile from item 54S1 originating from a single female individual. Assuming one individual, the DNA profile from 54S1 is at least 7.2 billion times more likely to occur if it originated from the source of the DNA profile from the swabbing of the electric toothbrush than if it originated from an unknown individual. Fotis Doulos and Michelle Troconis are eliminated as the source of the DNA profile from 54S1.
And is it also fair to say that all the Doulos children, Lauren Almeida and Pavel Gumiani, were eliminated as well?
Yes, that is correct.
And just to refresh the jury's memory, when you say that something is consistent with being a single female or a single contributor, what does that mean exactly?
That there is no evidence of more than one person contributing to that profile.
And just for the record, 54S1 was identified as a reddish brown stain along the short edge. Is that correct?
Yes, mine is, it's called a stain on a sponge along short edge.
And I want to direct your attention now to 54S2, which is identified as a reddish brown stain near short edge. What were the results with respect to that?
The results are consistent with the DNA profile from item 54S2 originating from a single female individual. Assuming one individual, the DNA profile from item 54S2 is at least 100 billion times more likely to occur if it originated from the source of the DNA profile from the swabbing of the electric toothbrush than if it originated from a known individual. Fotis Doulos, Michelle Troconis, and all other knowns are eliminated to that single female profile.
And swabbing 54S3 was identified as swabbing of areas on yellow portion. I'm displaying the photo lab 54S3. What were the results of your DNA analysis for that particular swabbing?
The results are consistent with the DNA profile from item 54S3 being a mixture of two contributors. Assuming two contributors, the DNA profile from item 54S3 is at least 100 billion times more likely to occur if it originated from the source of the DNA profile from the swabbing of the electric toothbrush and one unknown individual than if it originated from two unknown individuals. Fotis Doulos is eliminated as a contributor to item 54S3. Assuming two contributors, given the low likelihood ratios calculated, the results are inconclusive as to whether Michelle Troconis could be a contributor to the DNA profile from item 54S3.
And then would it be also fair to say that the Doulos children, Lauren Almeida and Pavel Gumiani, were eliminated as contributors to this profile?
Yes, that is correct.
Just going to read a stipulation, paragraph 5 of States 103. State Police Exhibit 502D, seized from Hartford by Sergeant Kevin Duggan on May 31st, 2019, and identified as one black rubber and fabric glove with dirt-like substance contained within State Police Exhibit 502, seized from the scene, corner of Albany Avenue and Green Street, Hartford, Connecticut, was subsequently submitted to the Division of Scientific Services and designated as submission 61. I'm just going to stay within that folder. And I'm going to display the photo entitled Lab 61S1 through 61S3. And for your benefit, Ms. Maydell, these results can be found in DNA report, supplemental reports 3, 9, and 18.
S1 was a swabbing of a glove interior palm side. The results are consistent with the DNA profile from item 61S1 originating from a single individual. The source of the DNA profile from the swabbing of the electric toothbrush is eliminated as a source of the DNA profile from item 61S1. Due to the limited data detected from 61S1, the comparison to Fotis Dulos and Michelle Troconis are inconclusive.
And were the results also inconclusive as to the Dulos children and Lauren Almeida?
That is correct, and Pavel is eliminated.
Now, with respect to 61S2, which is identified as a swabbing of a reddish brown soil type staining on the exterior palm side cuff edge, what were the results?
The results are consistent with the DNA profile from item 61S2 originating from a single individual. Due to the limited data detected from item 61S2, the comparison to the source of the DNA profile from the swabbing of the electric toothbrush is inconclusive. Fotis Dulos, Michelle Troconis are eliminated as a source of the DNA profile from 61S2.
And with respect to the children, were the results inconclusive as to them?
That is correct, and Lauren and Pavel are eliminated.
And 61-1S3, which was identified as swabbing soil type deposits exterior palm side cuff area, you did not get a profile for that particular test, correct?
61S3, correct. No DNA profile was detected.
And I'm opening up the photo entitled Lab 61S4 and 61S5. 61S4 was identified as swabbing of interior palm side. Can you indicate for the jury what the results were with respect to the interior palm side of this particular glove?
The results are consistent with the DNA profile from item 61S4 originating from a single individual. The source of the DNA profile from the swabbing of the electric toothbrush is eliminated as the source of the DNA profile from item 61S4. Assuming one individual, DNA profile from item 61S4 is at least 27,000 times more likely to occur if it originated from Fotis Dulos than if it originated from an unknown individual. Michelle Troconis is eliminated as a source of the DNA profile from 61S4.
And also fair to say the Dulos children, Lauren Almeida and Pavel Gumieni, were eliminated as well, correct?
That is correct.
And 61-1S5, which was identified as swabbing of interior back of hand. Can you indicate to the jury what the results were for that particular swab?
Results are consistent with the DNA profile from item 61S5 being a mixture of two contributors. The source of the DNA profile from the swabbing of the electric toothbrush is eliminated as a source of the DNA profile from item 61S5. Assuming two contributors, given the low likelihood ratio calculated, the results are inconclusive to whether Fotis Dulos could be a contributor to the profile from 61S5. Michelle Troconis is eliminated as a contributor to the DNA profile from item 61S5. The results do not support the hypothesis that Petros Dulos or Theodore Dulos are contributors to this profile. Assuming two contributors, Petros Dulos and Theodore Dulos, are eliminated as contributors to item 61S5. Assuming two contributors, given the low likelihood ratios calculated, the results are inconclusive as to whether Constantine, Christiane, or C. Noel Dulos could be contributors to the DNA profile from item 61S5. Lauren and Pavel are eliminated as contributors.
Publishing paragraph 6 of states 103. State police 31st, 2019, and identified as one pair of black husky gloves contained in State Police Exhibit 502, seized from the scene, corner of Albany Avenue and Green Street, Hartford, Connecticut, was subsequently submitted to the Division of Scientific Services and designated as submission 62. I'm going to open that folder. Just going to display the photograph entitled Lab 62-1S1. 62-1S1 was identified as the swabbing of left glove interior palm side. Can you indicate to the jury what the results were?
The results are consistent with the DNA profile from item 62-1S1 originating from a single female individual. Assuming one individual, the DNA profile from item 62-1S1 is at least 100 billion times more likely to occur if it originated from the source of the DNA profile from the swabbing of the electric toothbrush than if it originated from an unknown individual. All other knowns are eliminated.
And 61-1S2 and 1S3, I'm now displaying that particular photograph, which shows the approximate area where those swabbings took place. Were the results the same, meaning that 100 billion times more likely to have originated from the profile generated toothbrush, and all other knowns were eliminated with respect to 62-1S2 and 62-1S3?
That is correct.
And just for the record, 62-1S2 was identified as reddish brown staining on exterior logo of back of hand, and 62-1S3 was identified as reddish brown staining areas on exterior wrist closure. I'd like to talk to you now about the right glove. We were just talking about the left glove, which was identified as 62-2. There were also swabbings taken of this. I'm displaying the photograph entitled Lab 62-2S1 and 62-2S3. 62-2S1 was identified as swabbing of right glove interior palm side. What were the results with respect to that?
Results are consistent with the DNA profile from item 62-2S1 originating from a single female individual. Assuming one individual, the DNA profile from 62-2S1 is at least 100 billion times more likely to occur if it originated from the source of the DNA profile from the swabbing of electric toothbrush than if it originated from an unknown individual. Otis Doulos, Michelle Troconis are eliminated as 62-2S1.
As are all other knowns, is that correct?
Yes, that is correct.
62-2S2 is identified as reddish brown staining on exterior logo on back of hand. I'm going to try to display that photograph. Here we go. This is photograph Lab 62-2S2 and 62-2S4. Could you indicate the results for 62-2S2?
The results are consistent with the DNA profile from item 62-2S2 being a mixture of two contributors. Assuming two contributors, the DNA profile from item 62-2S2 is at least 100 billion times more likely to occur if it originated from the source of the DNA profile from the swabbing of the electric toothbrush and one unknown individual than if it originated from two unknown individuals. Otis Doulos is eliminated as a contributor to the DNA profile from 62-2S2. The results do not support the hypothesis that Michelle Troconis is a contributor to this profile. Assuming two contributors, Michelle Troconis is eliminated as a contributor to DNA profile from 62-2S2.
And with respect to the children?
Given the, assuming two contributors, given the low likelihood ratios calculated, the results are inconclusive as to whether Petros, Constantine, Christiane, C. Noel, or Theodore could be contributors to the profile from 62-S2. The results do not support the hypothesis that Lauren Almeida is a contributor to this profile. Assuming two contributors, Lauren Almeida is eliminated as a contributor to this profile, and Pavel is also eliminated as a contributor, 62 2S2.
And Judge, I just have two more swabbings for this particular submission and then perhaps the morning recess.
Yes.
Directing your attention now to 62 2S3, which is identified as reddish brown staining, stitching on wrist closure, palm side. Could you indicate to the jury what the results were? And this is in 3, 9, and 18.
The results are consistent with the DNA profile from item 62 2S3, originating from a single female individual. So this same conclusion, the ceiling stat and everybody else is eliminated.
Okay, when you say the ceiling stat, it's
100 billion times more likely.
that it originated from the profile generated on the toothbrush?
Yes, versus an unknown individual.
And just with respect to 62 2S4, which is identified as reddish brown staining on the stitching on wrist closure, back of hand.
Same conclusions,
In other words, 100 billion times more likely to be the profile from the toothbrush.
correct. Than an unknown individual, and everybody else is eliminated.
Judge, is this a good time to take the morning recess?
Yes. We'll stand in our morning recess, ladies and gentlemen. Please do not discuss the case. The council stipulate, please.
Yes, Judge.
Yes.
Thank you.
Just going to publish the stipulation, Your Honor, 103, paragraph 7. State Police Exhibit 502H, seized from Hartford by Sergeant Kevin Duggan on May 31st, 2019, and identified as 4 large white zip ties with blood-like substance contained within State Police Exhibit 502, seized from the scene, corner of Albany Avenue and Green Street, Hartford, Connecticut, was subsequently submitted to the Division of Scientific Services and designated as submission 52. And now I'm in State Trial Exhibit 109 in the lab submission 52 folder. And I'm displaying the photograph entitled 52 1S1 through 52 4S1. I want to just direct your attention now to some swabbings that were taken of this particular submission. And Ms. Maydell, for your benefit, the results can be found in your report, supplemental reports 2, 9, and 18. Beginning with 52 1S1, swabbing of surface, including stains. Can you indicate to the jury what the results were?
The results are consistent with the DNA profile from item 52 1S1, originating from a single female individual. Assuming one individual, the DNA profile from item 52 1S1 is at least 100 billion times more likely to occur if it originated from the source of the DNA profile from the swabbing of the electric toothbrush than if it originated from an unknown individual.
And Attorney
And-
McGinnis, would you again remind the jury about what they are seeing on the screen?
Yes, Judge, these were the zip ties seized from Hartford, Exhibit 502H, submission number 52.
Thank you.
And all other knowns were eliminated as a contributor.
And just to just to be clear, so the profile was, it was 100 billion times more likely to have been generated by the profile you found on the electric toothbrush than an unknown individual. Is that correct?
Correct.
And it was a single female profile?
Correct.
And with respect to swabbings 52 2S1, swabbing of surface including stains, 52 3S3, swabbing of surface including stains, and 52 4S1, swabbing of surface including stains. Were the results identical?
Yes, they were.
And I'm displaying lab 52 3S2. That's a photograph. What were the DNA results for swabbing 52 3S2 identified as a reddish brown stain?
The same results as the other 4 from the zip ties.
Single female, 100 billion times more likely to be the profile from the electric toothbrush.
Yes, and all other knowns eliminated.
Publishing paragraph 8 of that same stipulation. State Police Exhibit 502I, seized from Hartford by Sergeant Kevin Duggan on May 31st, 2019, and identified as one white standard textile towel with blood-like substance contained within State Police Exhibit 502, seized from the scene, corner of Albany Avenue and Green Street, Hartford, Connecticut, was subsequently submitted to the Division of Scientific Services and designated as submission 53. I'm going to open up that folder in State Trial Exhibit 109. And I'm opening the photograph entitled Lab 51 3S1 and 53 S2. With respect to the swabbing 53S1, which was a swabbing of a portion of a reddish brown stain, what were the results?
The results are consistent with the DNA profile from item 53S1 being a mixture of 2 contributors. Assuming 2 contributors, the DNA profile from item 53S1 is at least 100 billion times more likely to occur if it originated from the source of the DNA profile from the swabbing of the electric toothbrush and 1 unknown individual than if it originated from 2 unknown individuals. Fotis Doulos and Michelle Troconis are eliminated as contributors to the DNA profile from 53S1.
And then with respect to the children?
Assuming 2 contributors, given the low likelihood ratios calculated, the results are inconclusive as to whether Petros, Constantine, Christiane, Sinel, or Theodore Doulos could be contributors to the DNA profile from 53S1. Lauren Almeida and Pavel Gumini are eliminated as contributors.
And I might stand corrected on that. It may not have been a swabbing. It may have actually been a cutting of the 53S1 may have actually been a cutting of the towel.
Mine is described as a portion of a reddish brown stain from towel.
Right. So it was actually a piece of the towel as opposed to a swabbing of the towel.
Correct. They normally would call it a swabbing, yes.
And then with respect to 53S2, which was I believe another cutting of a reddish brown stain. Is that correct?
It might be a different report.
Oh, I'm sorry. That's supplemental report number 3.
Yes. 53S2 is a reddish brown stain from a towel. The results are consistent with the DNA profile from item 53S2 originating from a single individual. The source of the DNA profile from the swabbing of the electric toothbrush is eliminated as the source of the DNA profile from item 53S2. Photostaulos and Michelle Troconis are also eliminated as the source of the DNA profile from 53S2.
I believe everyone was eliminated from this. Is that correct?
Double check.
Sure.
Yes, correct. Everybody's eliminated.
I'm just going to go to State Trial Exhibit 111A. And I'm going to open the folder, State Police 502I Lab Submission 53, and display the photograph Lab 53S3-1. Now, with respect to Lab Submission 53S3-1, the results are found in your supplemental report number 12, Ms. Madell. This was identified as a human hair by Ms. Velonis. And can you just indicate to the jury what type of testing you did on this and what the results were?
Sure. I attempted to obtain a nuclear DNA profile, was not able to. So I then processed mitochondrial DNA on the shaft. And I generated not a full mitochondrial DNA profile, a partial. And the mitochondrial DNA sequence obtained from item 53S3-1 and number 45, which is the known from photostaulos, are the same. Therefore, photostaulos or another member of the same maternal lineage cannot be excluded as the source of the item 53S3-01. So then I searched the database of that partial profile to see how frequent that profile is seen. In the African American population, you would expect to see it more than 0.12%, Caucasian 0.11%, and the Hispanic 0.12%. All other knowns were excluded as being the possible source of that mitochondrial DNA sequence.
In that same State Trial Exhibit 111A, I'm opening the folder Lab Submission 55. And I'm going to publish paragraph 9 of the stipulation. State Police Exhibit 502J, seized from Hartford by Sergeant Kevin Duggan on May 31st, 2019, and identified as one red and black bent broom/mop handle with blood-like substance on the black handle, contained within State Police Exhibit 502, seized from scene, corner of Albany Avenue and Green Street, Hartford, Connecticut, was subsequently submitted to the Division of Scientific Services and designated as Submission 55. I'd like to begin talking to you about swabbings that were taken of this particular item, specifically 55S2, which was reddish brown deposits inside of the broken end. And I'm just going to zoom in here to the upper left-hand corner of this image. What were the results?
The results are consistent with the DNA profile from item 55S2 originating from a single female individual. Assuming one individual, the DNA profile from item 55S2 is at least 100 billion times more likely to occur if it originated from the source of the DNA profile from the swabbing of the electric toothbrush than if it originated from an unknown individual. And all other knowns are eliminated.
And then with respect to 55S3, which was identified as a reddish brown stain on black cap, 55S4 identified as a reddish brown stain near broken end, and 55S5 swabbing of metal portion of handle. Were those results identical?
Yes, they were.
I'm just jumping back to State Trial Exhibit 109. For the first several of the next results, Ms. Maydell, for your benefit, DNA reports 4, 9, and 18, and I'll let you know when we jump ahead. Judge stipulated between the parties 502K was the 4 pieces of black garbage bag seized from Hartford and given lab submission number 88. And I'm just going to open the folder, lab submission 88, and the subfolder 88-1. Displaying the photograph 88-1S1. This was identified as swabbing of black duct tape, non-adhesive side. What were the results?
The results are consistent with the DNA profile from item 88-1S1 originating from a single female individual. Assuming one individual, the DNA profile from item 88-1S1 is at least 100 billion times more likely to occur if it originated from the source of the DNA profile from the swabbing of the electric toothbrush than if it originated from an unknown individual. All other knowns are eliminated.
Displaying photograph lab 88.1S2. This was identified as swabbing from tangle of black tape, non-adhesive side. What were the results?
The results are consistent with the DNA profile from item 88-1S2 being a mixture of 2 contributors. Assuming 2 contributors, the DNA profile from item 88-1S2 is at least 3.9 million times more likely to occur if it originated from the source of the DNA profile from the swabbing of the electric toothbrush and 1 unknown individual than if it originated from 2 unknown individuals. Foetus doulos is eliminated as a contributor to the DNA profile. Assuming 2 contributors, given the low likelihood ratios calculated, the results are inconclusive as to whether Michelle Troconis could be a contributor to the DNA profile from 88-1S2.
And can I actually ask you a follow-up question to that? That was under the original DNA kit, is that correct?
This was the Fusion 6C kit, correct?
But you used Global Filer in 2023, is that correct?
For the known, correct.
And so in 2023, the defendant, when you analyzed the profile again, she was actually eliminated as being a contributor to this particular profile. Is that correct?
Let me just double check.
Sure.
That is correct. The results do not support the hypothesis that Michelle Troconis is a contributor to this profile. Assuming 2 contributors, Michelle Troconis is eliminated as a contributor to the Fusion 6C DNA profile.
Can you just explain to the jury again how it is that she went from being inconclusive under the first kit to eliminated under the second kit?
Well, when we did our comparison, we lost those 2 testing sites with information. So she went from having a little bit more information to put her in the inconclusive range to not having that information. So it eliminated her.
And then with respect to the children on this particular swabbing? And that's in DNA sub 9.
Given the low likelihood ratios calculated, the results are inconclusive as to whether Petros, Christiane, C. Noel, or Theodore could be contributors to the profile from DNA profile from item 88-1S2. Assuming 2 contributors, the DNA profile from item 88-1S2 is at least 12,000 times more likely to occur if it originated from Constantine doulos and 1 unknown individual than if it originated from 2 unknown individuals. And Lauren and Pavel are eliminated.
Displaying Lab 88 1S3, which was identified as a reddish brown stain exterior of non-damaged plastic bag. And this is in DNA sub 4. What were the results?
The results are consistent with the DNA profile from item 88 1S3 originating from a single female individual. Assuming one individual, the DNA profile from 88 1S3 is at least 100 billion times more likely to occur if it originated from the source of the DNA profile from the swabbing of the electric toothbrush than if it originated from an unknown individual. And all other knowns are eliminated.
And then Lab 88 1S4, I'm displaying that photograph. This was identified as reddish brown staining interior of damaged plastic bag. What were the results?
The results are consistent with the DNA profile from item 88 1S4 being a mixture of 2 contributors. Assuming 2 contributors, the DNA profile from item 88 1S4 is at least 100 billion times more likely to occur if it originated from the source of the DNA profile from the swabbing of the electric toothbrush and 1 unknown individual than if it originated from 2 unknown individuals. The results do not support the hypothesis that photostulose is a contributor to this profile. Assuming 2 contributors, photostulose is eliminated as a contributor to this profile from 88 1S4. Michelle Troconis is eliminated as a contributor to this profile.
And then with respect to the children,
Given the low likelihood ratios calculated, the results of all 5 children are inconclusive, and Lauren and Pavel are eliminated.
displaying photograph Lab 88.1S6. Lab 88-1S6 was identified as a swabbing from exterior opening of non-damaged plastic bag. And this is in DNA supplemental report number 5, 10, and 18 for your benefit, Ms. Maydell.
The results are consistent with the DNA profile from item 88-1S6 being a mixture of 4 contributors, with at least one of them being male. Assuming 4 contributors, the DNA profile from item 88-1S6 is 100 billion times more likely to occur if it originated from the source of the DNA profile from the swabbing of the electric toothbrush and 3 unknown individuals than if it originated from 4 unknown individuals. The results do not support the hypothesis that photostulose is a contributor to this profile. Assuming 4 contributors, photostulose is eliminated as a contributor to item 88-1S1. Assuming 4 contributors, given the low likelihood ratios calculated, the results are inconclusive as to whether Michelle Troconis could be a contributor to the DNA profile from item 88-1S6.
And the Dulos children, Lauren Almeida and Pavel Gumieni, were eliminated. Is that correct?
The results do not support the hypothesis that the 5 Dulos children are contributors. They are eliminated, and Lauren and Pavel are also eliminated.
And 88-1S7, which was identified as swabbing from exterior opening of damaged plastic bag. You did not develop a profile on that particular swabbing, correct?
Correct. No nuclear DNA profile was detected.
And with respect to just going to jump back to State Trial Exhibit 111A. lab submission folder 88, subfolder 88-1. There was a yellow and green sponge located within submission 88-1. And there were swabbings taken of that. And I'm just going to display lab 88.1.1S1. What were the results of the swabbing lab 88-1-1S1? And that's in DNA sub 4. I believe no profile was obtained. Is that correct?
88-1-1S1.
That's correct.
Correct. No DNA profile was obtained.
I can't remember if I asked you this earlier, but how is it possible that a profile was not obtained?
There's just not enough DNA there to be detected in our system.
And then there was also a human hair removed from that sponge. I'm displaying a photograph entitled Lab 88.1.1S2 and directing your attention to DNA supplemental report number 12. Can you just indicate to the jury what type of testing you did on this hair and what the results were?
Again, I attempted to get nuclear DNA profile from this hair and I did not. So then I tested it for mitochondrial DNA and obtained a full mitochondrial DNA profile. And in comparing the mitochondrial DNA profile from 88-1-1S2-01 and the known from 94, submission number 94, which is Pavel's known, are the same. Therefore, Pavel Gumini or another member of the same maternal lineage cannot be excluded as the source of item 88-1-1S2-01. So searching the database of that profile, I would not expect to see this profile in more than 0.12% in the African American population, 0.36% in the Caucasian, 0.12% in the Hispanic, 0.46% in the Asian, or 0.46% in the Native American populations. All other knowns were excluded as being the possible source of that mitochondrial DNA sequence.
Just jumping back to State Trial Exhibit 109. And lab submission number 88, folder 88-1. And I'm going to display the photograph lab 88.1.2S1. There was a black plastic garbage bag that was folded and found within inside 88-1. And the swabbing 88-1-2S1 was identified as a brownish stain from the exterior. What were the results of that? And this is in 4, 9, and 18.
S1 did not generate a nuclear DNA profile.
I'm sorry, 88-1-2S1.
1-2S1, sorry.
That's okay.
1-2S1.
DNA sub 4.
Yes. The results are consistent with the DNA profile from 88-1-2S1 originating from a single female individual. Assuming one individual, the DNA profile from item 88-1-2S1 is at least 100 billion times more likely to occur if it originated from the source of the DNA profile from the swabbing of the electric toothbrush than if it originated from an unknown individual, while other knowns are eliminated.
I'm just going to go to subfolder 88-2. 88-2 was identified as one black plastic garbage bag. And there were swabbings taken of this as well. And for your benefit, Ms. Maydell, this is in 4, 9, and 18. Just beginning with 88-2S1, which was identified as a swabbing of latent print partially outlined exterior. Would it be fair to say that no profile was developed from that particular swabbing?
That is correct.
With respect to 88-2S2, which was identified as a reddish brown stain exterior, what were the results?
The results are consistent with the DNA profile from item 88-2S2 originating from a single female individual. Assuming one individual, the DNA profile from item 88-2S2 is at least 100 billion times more likely to occur if it originated from the source of the DNA profile from the swabbing of the electric toothbrush than if it originated from an unknown individual, and all other knowns are eliminated.
And 88-2S3 was identified as a brownish stain on the exterior.
The results are consistent with the DNA profile from item 88-2S3 originating from a single individual. Assuming one individual, the DNA profile from item 88-2S3 is at least 880,000 times more likely to occur if it originated from the source of the DNA profile from the swabbing of the electric toothbrush than if it originated from an unknown individual. Fotis Doulos and Michelle Troconis are eliminated as the source of the DNA profile from 88-2S3.
And 88-2S4 was identified as swabbing of brownish stain exterior. That was actually identified as belonging to a member of the Scientific Services Laboratory. Is that correct?
That is correct. And if I can just say for 88-2S3, all other knowns were eliminated too.
Oh, sorry.
No, that's okay. I didn't get to that. But yes, 88-2S4 had laboratory staff contamination, so there's no comparisons for that.
And is everyone that works at the laboratory required to submit a DNA sample, or what does that look like?
Yes, we have what we call a staff index. So when all of our DNA profiles are completed an analysis, before we write a report or do any comparisons, we search all those profiles from the evidence against our staff index that no contamination occurred.
Okay. And so in this particular instance, contamination was noted, so no additional comparison was done, correct?
That is correct, yes.
And with respect to 88-2S5, which was identified as a reddish brown stain from garbage bag exterior, what were the results of that?
The results are consistent with the DNA profile from item 88-2S5 originating from a single female individual. Assuming one individual, the DNA profile from 88-2S5 is at least 6.5 billion times more likely to occur if it originated from the source of the DNA profile from the swabbing of the electric toothbrush than if it originated from an unknown individual, and all other knowns are eliminated.
And with respect to 88-2S6, which was identified as swabbing from opening exterior,
The results are consistent with the DNA profile from item 88-2S6 originating from a single female individual. Assuming one individual, the DNA profile from item 88-2S6 is at least 100 billion times likely to occur if it originated from the source of the DNA profile from the swabbing of the electric toothbrush than if it originated from an unknown individual. All other knowns are eliminated.
and displaying the photograph entitled Lab 88-2S7, identified as a swab, a reddish brown stain interior. No profile was developed from this particular swabbing. Is that correct?
That is correct, yes.
And displaying the photograph Lab 88-2S8. This was identified as reddish brown stain interior. What were the results of this analysis?
The results are consistent with the DNA profile from item 88-2S8 originating from a single female individual. Assuming one individual, the DNA profile from item 88-2S8 is at least 1.9 billion times more likely to occur if it originated from the DNA profile from the swabbing of the electric toothbrush than if it originated from an unknown individual, and all other knowns are eliminated.
Just going to publish the stipulation, Your Honor, paragraph 11. State Police Exhibit 502S seized from Hartford by Sergeant Kevin Duggan on May 31st, 2019, and identified as one metal scraper with a broken blade contained within State Police Exhibit 502, seized from the scene, corner of Albany Avenue and Green Street, Hartford, Connecticut, was subsequently submitted to the Division of Scientific Services and designated as submission 40. I'm going to open up the folder for submission 40 and display the photograph entitled Lab 40S1 and 40S2. I want to direct your attention now. This can be found in DNA reports 2, 9, and 18 for your benefit. So with respect to swabbing 40S1, which was identified as a swabbing of blade and blade holder, could you indicate to the jury what the results of your analysis were?
The results are consistent with the DNA profile from item 40S1 being a mixture of 2 contributors. Assuming 2 contributors, the DNA profile from item 40S1 is at least 100 billion times more likely to occur if it originated from the source of the DNA profile from the swabbing of the electric toothbrush and 1 known individual than if it originated from 2 unknown individuals. Fotis Doulos and Michelle Troconis are eliminated as contributors to 40S1.
And would it be fair to say that the children, Lauren Almeida and Pavel Gumieni, were eliminated as well?
That is correct, yes.
And with respect to 40S2, which was identified as swabbing of tool, what was the results of your DNA analysis?
The results are consistent with the DNA profile from item 40S2, originating from a single female individual. Assuming 1 individual, the DNA profile from item 40S2 is at least 100 billion times more likely to occur if it originated from the source of the DNA profile from the swabbing of the electric toothbrush than if it originated from an unknown individual, and all other knowns are eliminated.
I'm going to publish State's Exhibit 104, which is a stipulation, specifically paragraph 3, and this is the stipulation with respect to the Toyota Tacoma. Paragraph 3, State Police Exhibit 207, seized from the Toyota Tacoma by Detective Matthew Riley on June 11, 2019, and identified as 1 cutting of upholstery fabric with blood-like stain, KM positive, seized from the scene, seatback, was subsequently submitted to the Division of Scientific Services and designated as submission 86. And I'm going to open up State Trial Exhibit 93. There's a subfolder entitled Tacoma for Court. And I'm going to display photograph 18. And Ms. Maydell, for your benefit, this can be found in DNA reports 3, 9, and 18. 86S1, which was identified as a swabbing of cutting of upholstery-like fabric. Could you indicate to the jury what the results were?
The results are consistent with the DNA profile from 86S1 originating from a single female individual. Assuming 1 individual, the DNA profile from item 86S1 is at least 100 billion times more likely to occur if it originated from the source of the DNA profile from the swabbing of the electric toothbrush than if it originated from an unknown individual, and all other knowns are eliminated.
Sorry, I'm just waiting for it to buffer. I'm just going to read the stipulation. This is paragraph 4 from States 104. State Police Exhibit 208, seized from the Toyota Tacoma by Detective Matthew Riley on June 11th, 2019, and identified as 2 swabs seized from the scene, front plate screws and surrounding areas, was subsequently submitted to the Division of Scientific Services and designated as submission 90. And I'm displaying photograph 1 in that same subfolder, Tacoma for court. Directing your attention to DNA supplemental report number 4, 90S1, identified as envelope with 2 swabs from front plate screws and surrounding area. Were you able to generate a DNA profile on those screws?
I did not.
If I could just have one moment, Your Honor. I'm displaying photograph 8. I'm just going to read the stipulation. This is paragraph 1. State Police Exhibit 203, seized from the Toyota Tacoma by Detective Matthew Riley on June 11, 2019, and identified as 2 swabs of blood-like stain, KM positive, seized from the scene, interior side of left door, was subsequently submitted to the Division of Scientific Services and designated as submission 84. And this is found in DNA sub 2. 84S1 was identified as 2 swabs of that blood-like stain. Were you able to generate a profile?
You said 84S1?
Yes.
No, DNA profile was generated.
Just going to read that stipulation, paragraph 2. State Police Exhibit 206, seized from the Toyota Tacoma by Detective Matthew Riley on June 11, 2019, and identified as 2 swabs of blood-like stain, KM negative, seized from the scene, interior side of right door, was subsequently submitted to the Division of Scientific Services and designated as submission 85. Were you able to generate a profile on those 2 swabbings? 85S1.
I did not. No DNA profile was detected.
Just going to jump back to State Trial Exhibit 109, the lab submission 97 folder, and read paragraph 5 of the stipulation. State Police Exhibit 323, seized from the Toyota Tacoma by Detective Matthew Riley on June 26, 2019, and identified as 1 Connecticut registration plate 6617CN with 2 screws for NCA/DP process, seized from the scene front, was subsequently submitted to Division of Scientific Services and designated as submission 97. And I'm displaying a photograph entitled Lab 97.1S1. Ms. Maydell, with respect to those particular swabbings, were you able to generate a profile?
Sorry, what DNA report is that?
Oh, certainly. It's DNA supplemental report number 6.
There was two different items that I tested, 97-1S1 and 97-2S1, and both did not generate a DNA profile.
And 2S1 was identified as one envelope with 2 screws, correct?
Mine was called swabbing from screws and washers.
Yes. I'm just displaying those screws for the jury, and you were not able to develop a profile on those as well?
Correct.
I'm just going to publish the stipulation again. Paragraph 6, State Police Exhibit 324, seized from the Toyota Tacoma by Detective Matthew Riley on June 26, 2019, and identified as 2 swabs seized from the scene, screw threads, in State Police Exhibit 323, was subsequently submitted to the Division of Scientific Services and designated as Submission 91. With respect to Submission 91, which became 91S1, the 2 swabs that were submitted, were you able to generate a profile? And that's in DNA sub 4.
No, 91S1, there was no DNA profile generated.
Opening the folder entitled Lab Submission 98. I'm going to publish paragraph 7. State Police Exhibit 325, seized from the Toyota Tacoma by Detective Matthew Riley on June 26, 2019, and identified as 1 Connecticut registration plate 6617CN with 2 screws paren CA/DP processed, seized from the scene rear, was subsequently submitted to the Division of Scientific Services and designated as Submission 98. And I'm just going to direct your attention now to the swabbing of 98-1 was identified as the license plate, and 98-2 was identified as the 2 screws that came with it. With respect to 98-1S1, what were the results of your DNA analysis?
The results are consistent with the DNA profile from item 98-1 originating from a single individual. The source of the DNA profile from the swabbing of the electric toothbrush, Fotis Doulos and Michelle Troconis, are eliminated as the source of the DNA profile from 98-1S1.
Would it be fair to say that with respect to 98-1S1, all of the known profiles that you examined were eliminated?
Just want to double check.
And that's in 10 and 18
Yes.
as well.
That is correct. All the knowns are eliminated.
And then with respect to 98-2S1, which was the swabbing of the screws and washers, what was the result of that?
The results are consistent with the DNA profile from item 98-2S1 originating from a single individual. Due to the limited data detected from 98-2S1, the comparison of the source of the DNA profile from the swabbing of the electric toothbrush is inconclusive. Fotis Doulos and Michelle Troconis are eliminated as the source of the DNA profile from item 98-2S1.
And with respect to the children? And that's in 10.
Sure. Due to the limited data detected from item 98-2S1, the comparison to Petros and Christiane Doulos are inconclusive. Constantine, C. Noel, Theodore, Lauren, and Pavel are all eliminated as the source of the DNA profile from 98-2S1.
Just going to publish that stipulation, paragraph 8, State Police Exhibit 326, seized from the Toyota Tacoma by Detective Matthew Riley on June 26, 2019, and identified as 2 swabs from the scene, screw threads, in State Police Exhibit 325, was subsequently submitted to the Division of Scientific Services and designated as submission 92. And this is found in DNA Sup 4, Ms. Maydell. 92S1 was identified as the envelope with those two swabs. Is it fair to say you were unable to generate a profile?
That is correct.
Opening submission 99. And displaying the photograph lab 99S5. Paragraph 9 of that stipulation, State Police Exhibit 363, seized from the Toyota Tacoma by Detective Matthew Riley on August 27, 2019, and identified as one interior door panel from right door, was subsequently submitted to the Division of Scientific Services and designated as submission 99. With respect to 99S5, which was identified as swabbing from edges of fabric panel and panel area, what were the results of your DNA analysis? And this is in 6 and 18 for your benefit.
The results are consistent with the DNA profile from item 99S5 being a mixture of 3 contributors. The results do not support the hypothesis that the source of the DNA profile from the swabbing of the electric toothbrush is a contributor. Assuming 3 contributors, the source of the DNA profile from the swabbing of the electric toothbrush is eliminated as a contributor to the DNA profile from item 99S5. The results also do not support the hypothesis that Fotis Dulos or Michelle Troconis are contributors to this profile. Fotis Dulos and Michelle Troconis are eliminated.
And were there any results with respect to the children?
Petros, Constantine, and Christiane, and Pavel are eliminated as contributors to the DNA profile from item 99S5. Assuming 3 contributors, given the low likelihood ratios calculated, the results are inconclusive whether C. Noel Dulos could be a contributor to the DNA profile from item 99S5. And the results do not support the hypothesis that Lauren Almeida or Theodore Dulos are contributors to this profile. Assuming 3 contributors, Lauren Almeida and Theodore Dulos are eliminated to the DNA profile from 99S5.
And now I'm going to display lab 99S6 through 99S8. (99S6) identified as swabbing from panel handle attachment area. 99S7 swabbing from panel handle area. 99S8 swabbing from panel openings for plastic cup and edges of plastic cups. 99S9 swabbing from panel opening for speaker and edges of speaker. And this is found in DNA supplemental report number 6. You were not able to generate a profile for any of those?
That is correct.
Ms. Maydell, would you expect that with a work truck that is used fairly frequently that there would be some DNA on a door handle?
Objection, speculation, and lack of foundation.
Sustained.
With respect to 99S11, which was identified as swabbing from handle, you did not generate a profile for that either, correct?
That is correct.
And jumping to State Trial Exhibit 111A, the submission 99S14, just displaying that photograph within that folder. This was identified as a human hair by Ms. DeLunas, coming from that particular submission. And I'll direct your attention to DNA Sup 12. Did you perform any analysis
Yes, I attempted nuclear DNA and mitochondrial DNA testing on the hair root and the hair shaft and did not generate a profile for either.
And with respect to 99S15, which was identified as swabbing from fabric area, what were the results?
No profile, my nuclear DNA profile was generated.
I'm going to stay within State Trial Exhibit 111A and open the Laboratory Submission 100 folder. And I'm just going to publish that stipulation, paragraph 10. State Police Exhibit 364, seized from the Toyota Tacoma by Detective Matthew Riley on August 27, 2019, and identified as carpeting cut from right floor, was subsequently submitted to the Division of Scientific Services and designated as Submission 100. And within this folder, I'm going to pull up the photograph entitled Lab 100.1S1 and 100.1S2. Specifically, the swabbing of 100-1S1, brownish staining located on top side. Were you able to generate a profile?
No, no DNA profile was obtained.
And with respect to 101S2, which was identified as brownish staining located on top side, were you able to generate a profile?
Yes, the results are consistent with the DNA profile from item 100-1S2 being a mixture of 3 contributors with at least one of them being male. The results do not support the hypothesis that the source of the DNA profile from the swabbing of the electric toothbrush is a contributor. Assuming 3 contributors, the source of the DNA profile from the swabbing of the electric toothbrush is eliminated as a contributor to the DNA profile from 101S2. The results do not support the hypothesis that Fotis Dulos or Michelle Troconis are contributors to this profile. They are eliminated.
Ms. Medill, I want you to assume the following facts are true. I want you to assume that on May 29th, 2019, the Toyota Tacoma belonging to Vel Gumieni was detailed at a car wash. How, if at all, could a car being detailed impact potential DNA evidence found in the car?
Well, as of any wiping or cleaning that we talked about before, that can remove any DNA that may be left behind or any biological material.
And could that also potentially prevent DNA profiles from being generated on objects tested?
Correct. We wouldn't have enough DNA to be detected, therefore would not generate a profile. I need to finish the conclusions for 101S2.
Oh, I'm sorry. Go ahead.
Okay. Assuming 3 contributors for the DNA profile from item 101S2 is at least 100 billion times more likely to occur if it originated from Pavel Gumieni and 2 unknown individuals than if it originated from 3 unknown individuals. The Dulos children and Lauren Almeida are eliminated.
Judge, I have what has been identified as State Exhibit 122. It's a stipulation between the parties. I would just move it into evidence formally with the court.
Do you wish to publish it?
Yes, Judge.
Thank you. Any objection?
No, Your Honor.
122,
Yes, sir.
states 122 admitted as well.
This is a stipulation regarding evidence seized from Fotis Dulos' 2015 Chevrolet Suburban and submitted to the Division of Scientific Services. Paragraph 1, State Police Exhibit 144, seized from Fotis Dulos' 2015 Chevrolet Suburban by Detective Matthew Riley on May 31st, 2019, and identified as 1 swab of a blood-like stain, KM positive, seized from the scene from State Police Exhibit 123, left side of WeatherTech floor liner, rear cargo area, was subsequently submitted to the Division of Scientific Services and designated admission 42. This can be found in your very first DNA report. Could you just indicate what the results were?
The results are consistent with the DNA profile from item 42S1 being a mixture of 3 contributors with at least one of them being male. The results do not support the hypothesis that the source of the DNA profile from the swabbing of the electric toothbrush is a contributor. Assuming 3 contributors, the source of the DNA profile from the swabbing of the electric toothbrush is eliminated.
And I believe it's also
Number 9.
ES and 18 as well, and perhaps also SUP 1.
Yes. Assuming 3 contributors, the DNA profile from item 42S1 is at least 41 million times more likely to occur if it originated from Fotis dulos and 2 unknown individuals than if it originated from 3 unknown individuals. Michelle Troconis is eliminated, the contributor to 42S1. Assuming 3 contributors, given the low likelihood ratios calculated, the results are inconclusive as to whether Petros, Constantine, Christiane, C. Noel, or Theodore could be a contributor to the DNA profile from 42S1. Lauren and Pavel are eliminated as contributors.
Your Honor, at this time, I'm just going to return exhibits 122, 103, and 104 to the clerk. I don't have anything additional, Your Honor.
Thank you. Attorney Schoenhorn.
I'm just going to need a minute to organize here. Just a moment. Is it afternoon? It is. Good afternoon again, Ms. Medell.
Good afternoon.
Looks like you were someplace sunny since the last time you were here.
Yes.
Any of it, but I wanted to ask you specifically about the exterior of the black garbage bags that we've talked about a lot, 88 dash, and then we have 1, 2, 3, et cetera. You know which ones I'm talking about if you want to pull out that.
Yes. Do you know which report it was? Are you referring to 883S7?
Yes.
The number supplemental DNA report 5.
Okay, so I'm actually back up a step. So when you received this item, these were 2 garbage bags, 88 that had been separated. Is that correct? 88-1 and 88-3 were 2 garbage bags that originally had been sort of connected together.
I never saw the garbage bags, so the FP people examine all those garbage bags, and they do the swabbings for DNA, and they put those swabbings or cuttings into a little tube and put them in a secure location for storage until I'm ready to go do my DNA testing. So I don't actually see those parent items.
Certain images were put up on the screen during your testimony, correct, today?
Sure, but I didn't turn around and look at them.
All right, so fair to say that you didn't see any of the items that Mr. McGinnis was displaying on the screen while you were doing your testing. Is that correct?
That is correct, yes.
As I understand it, the swab of 88-3S7, and I sort of was from the edge. So shall we say the exterior edge of the garbage bag, correct?
My description is the swabbing of bag opening and separate bag portion.
Okay, but when we're talking about the opening, you're talking about the place where you would open a garbage bag to put stuff in, correct?
I would say that's correct from the description.
And the image that was displayed at the time was written, it said exterior. Would that be fair to say that the swab was from the exterior of that opening of the bag?
I can't say that because I didn't take the swabbing and that's not in my description.
In any event, you used at the time the Fusion 6C program in order, or the kit in order to obtain a DNA profile or profiles from that swab, correct?
That is correct, yes.
In order to do that, you actually you determine from the swab after you put it into a tube, right? You make it into a liquid, correct?
Yes, create a DNA extract.
And you actually from that are able from the Fusion 6C kit to determine the weight, or shall we say quantity of that sample, correct?
No, it's actually before that step. The Fusion 6C step is when we're actually making the copies of the DNA. That second step called quantification is when we determined how much DNA we think we have. And then we use that Fusion 6C kit to make make more copies of it.
Okay, so as I think you explained, when you talk about making copies, it's almost like you're taking a tiny, tiny actual sample and you're making like photocopies of it, only it's not really photocopies. It just multiplies the DNA into a larger quantity. Is that correct?
Yes, hoping we can detect DNA profile.
But when we're talking about a quantity, it comes in nanograms and picograms, correct?
That is correct. When we do the quantification, it tells us how many nanograms or picograms we have of that sample from that DNA extract from the swab.
And that is indicated in a Fusion 6C PowerPlex chart that comes out, correct?
I'm not necessarily the nanograms or the picograms. That's in the quantifier report. The electropharogram that's at the end is represented by a series of peaks.
It's my understanding that ideally, at least in 2019, the quantity of sample that you would prefer to be able to do a profile would be at least half a nanogram, 0.500 picograms, correct?
0.500 is 500 picograms or half a nanogram, and that was our target. That's what we target. If we have enough DNA, that's the amount that we want, that we're pretty sure we would get a full DNA profile, yes.
But if you had less than that, you would still try to produce a profile, correct?
Yes, that is correct.
Your lab, even in 2019, sophisticated enough so that it could at least obtain a partial profile down to, I forget the number, but quite a lot less than the 500 picograms, correct?
Yes, that is correct. We can get a partial profile from a lot less.
Right. So, could I have one? These are from the lab things. Injection was on this one. I don't have an injection. This I haven't seen, John's. Right. Somebody have 3 pictures. And but I'll also, we can do So I understand that with regard to exhibit V, there's no objection.
What was the,
Defense.
what was the exhibit?
V as
V is in Victor, no problem, no objection.
Defense V as in Victor, admitted as false.
All right, I'm going to show you, I guess, if I could have. We could get the monitor turned on, please. All right, so you recognize this as an amplification worksheet?
Yes, that is correct.
And if we look at the number one, there's more than one of the samples that you talked about today, correct?
Correct. There's 3 different swabbings listed there with the controls.
Oh, when you,
Sorry, there's 3 separate.
let me do this. There is a separate microphone. If I could please maybe,
Yes, along with 88307, there was 2 other swabbings amplified at the same time with the controls.
And so that we're talking about the same thing. This is the 3S7 one I just asked you about, correct?
That is correct, yes.
And if we go across, the NG stands for nanograms, correct, of DNA, right?
Correct, yes.
And the amount that's listed just below that is 0.42, correct?
Correct. So that's 420 picograms or 0.42 nanograms.
That was the total sample that was in the, that was the total quantity in the sample that you tested, correct?
Approximately the amount of, yes, DNA that I was amplifying.
And even though that was slightly less than the 500, well, let's do a little math and I'll do that a little bit later, but there are 1,000 picograms in 1 nanogram, right?
Yes,
And to remind us from the last time I asked you this, a picogram is a trillionth of a gram, right?
correct, yes.
So this would be 420 trillionths of a gram of DNA that you used, right?
Well, 1 picogram is a trillionth.
Or is it, yeah,
You-
because these are nanograms, well, I guess,
But it's 420 picograms, so it wouldn't be 400 trillionth of a gram.
well, it's,
It's a lot less than a gram.
yes, right. But it's also a lot less than a nanogram, right? It's
It's
less than half of
almost-
a nanogram.
Yes, because a half a nanogram would be 0.5.
Okay, all right, fair enough. So, you were able to, by using this profile, you were able to run a star mix deconvolution program report on this sample, correct?
Correct.
Okay, so I'm going to then show you a page from the, well, before I even show you the next thing, the deconvolution report will take the sample and it will run the program and create probabilities based on the input that you put in, correct?
I give it the DNA profile that is generated, and then it generates a likelihood ratio when you make a comparison, correct?
In this particular case, you, after using, you called it electrophoresis. That's the program that you run to look at peaks and valleys to determine how many contributors you believe are involved in a particular sample, correct?
Well, the electrophoresis is actually separating those DNA types, and then I look at the profile to determine how many contributors I believe it is.
Okay, and in this particular sample, according to your testimony, you believe there were 4 different people, 4 different DNA sources for this particular sample, correct?
That is correct, yes.
And the one below it, I'll just note, was even small sample, right? The 0.33 was from 881S 6, correct?
Yes, that was the highest we could get to, yes.
And that's the one where you said that any comparison to the DNA profile of my client was inconclusive, correct?
I'd have to refresh my recollection.
Sure. Would you like to do that with
Sure.
what, that's 1S6?
1S6. Yes, in supplemental DNA report 5, the likelihood ratios calculator make it inconclusive.
An inconclusive mean there wasn't enough sample for you to make any either a exclusion or to even make it be a partial inclusion, correct?
Not necessarily enough sample, but when we generated our likelihood ratio, it fell above our elimination, but fell below what we deem a positive association. So we say it's inconclusive. We
And
can't,
so you make no opinion about it, correct?
correct.
Okay. And incidentally, the lab switched from this Fusion 6C to Global Filer in what year?
The end of 2019, beginning of 2020.
So at that point, the lab decided to use Global Filer because it was what, more sophisticated, that program?
No, it was because we were switching vendors and and the machines at the same time. So they just switched vendors.
But in any event, you explained why they test for less loci on a DNA strand, but the outcome showed a lower probability likelihood ratio after you reran Michelle Troconis's DNA in 2023, correct?
That is correct because I had 2 less sites for the comparison.
Right, it went down to 250,000 to 1 as a likelihood, correct?
That was a likelihood ratio, yes.
Assuming 4 contributors and 3 unknowns, right?
That is correct, yes.
Okay. So I'm going to ask you, I'm going to pull up a page from the deconvolution report. And before I do that, the deconvolution report also estimates the percentages of the 4 contributors to a mixture, correct?
Yes.
So I'm going to put up, I think it's marked as deconvolution. All right, could you zoom in on the bottom part, please? Well, let's start at the top here. This is from your 2019 STR mix report, correct?
Yes.
This is their logo showing an untangling of a bunch of string up in the corner, correct?
Sure, yes.
All right. And again, so that the jury will understand what we're looking at here, this shows that the file was 88-3S7, correct?
Yes.
That's the same number throughout. If anything that you testified about regarding this sample, it'll show 88-3S7, correct?
Correct.
And then and below that, it talks about the known contributor, and it's got the number 45-2G1. And for the juror's edification, you've already explained this, 45 is the sample that was assigned to the known profile of Michelle Troconis, right?
I believe 45 was Fotis Doulos. 47 was Troconis? Let me just make sure. Yes, 45 is Fotis Doulos and 47 is Michelle Troconis.
All right. So this report you ran against Fotis Doulos as a known contributor, correct?
Yes.
And if you go down to the bottom, all right. So when you ran this amount, it showed that 50% of the sample, right, according to Star Mix, was Fotis Doulos's, correct?
Well, yes, it approximates how much each contributor is contributing to that profile before you make a comparison. It deconvolutes the whole profile and gives you the weights for those 4 people that I told it was. And then when you do the comparison with the known, it then tries to see by its already deconvoluted parts if the known matches to any of what the best explanations
Okay.
are.
Well, what I want you to do is when you look at the proportions of 1, 2, 3, and 4, when you ran it against unknowns, correct?
Well, you only run it against the one known at a time.
Okay, well, that's what I was trying to get at. And in this particular case, the third, shall we say, the third highest contribution, or the third lowest, if you will, was percent, correct?
The third contributor is contributing 5%, approximately 5% of the DNA profile, correct?
5% of 100%, correct?
Correct.
And then the fourth person was 3%, right?
Approximately, yes.
Okay, so if we would go to the LR 47 report. Right, so this is a report that was written, well, that was part of a deconvolution report and likelihood ratio from August of 2019, correct?
Correct.
And this is a report you ran using star mix, correct? STR mix.
Correct.
And in this particular sample, we used 47 as the known contributor, correct?
Correct.
And again, you only run one at a time, as you said, correct?
Correct.
So if you would just go down to the lower part of this, okay? And we've already, so in this, it shows the location within the four profiles, separate DNA profiles, for the known sample of Michelle Troconis, correct?
Yes, it fits her to contributor number 3.
Right, and in that case, that would be a 5% of the total, is that right?
Approximately, yes.
And then you reran this, as I think you indicated, in 2023. So if you would pull up 147, 2023, please. Okay, so up at the top, you ran this again in November of 2023, right?
Correct. After I redid the known with global filer.
Right. So let me also just indicate you were given a newer, more recent DNA sample of my client, correct?
Correct.
Now, her DNA didn't change in the 4 years since it was originally provided, did it?
No, of course not.
Okay. So when you go down to the bottom, it still came out third, correct? In 2023, correct?
Correct, yes.
And as I understand this, the first time you ran it using the Fusion 6C, it was in 2019. It was, the results were cannot be eliminated, correct? That's what you called it, right?
Yes, because that was the terminology we were using at the time.
And then now you use the terminology consistent with source, correct?
Consistent with the contributor for a mixture.
All right. But in any event, it was still only a partial DNA that you were comparing my client's known DNA against, correct? A partial profile, right?
Correct. Her full profile wasn't detected in this 4-person mixture.
So if we do this, the math, if you started with 420 picograms, right? If you go back to the deconvolution report, that one, and then zoom in at the percentages here, right there. All right. So if we assume there was a total of 420 picograms, right? That means 50% of the sample belonged, in this case, to Mr. Doulos, correct?
Approximately, yes.
And when you swiped, excuse me, you didn't actually do the swiping for the sample in this case, correct?
You mean the swabbing of the bag?
The swabbing,
I did not know.
right? Someone else ran it somewhere along the exterior edge of that bag, correct?
From the description, it was the opening of the bag, yes.
Okay. And if I look at them, I'm not going to do the next, the 42% is the next one, but if we go down to 5%, so 10% of 420 picograms would be 42 picograms, correct?
Correct.
And 5% of 420 picograms would be 21 picograms, correct?
Correct.
The last time we were here, I believe you estimated that approximately one human skin cell has a little more than 6 picograms, correct?
Correct. I agree with that.
So maybe 6.5, does that sound about right?
Yeah, somewhere around 6.
So if I'm to do the math correctly, there were 3 human skin cells that may have contributed to this front that are that could not be eliminated from Ms. Troconis's profile, correct?
Approximately, that's, yes, a fair statement.
3 skin cells, right?
Approximately,
Right. So that would be
Yes,
21 trillionths of a gram of DNA, right?
Well, Judge, I'm just going to object at this point. I don't think it's relevant because there's no indication that this DNA actually came from skin cells. So to make the leap that this is actually skin cell DNA, I think is a bridge too far at this point.
Well, the court heard the testimony of the witness that 6.5, 21 divided by 6.5 is approximately 3. So there's redirect examination for clarification, but the objection is overruled.
That's correct, right?
well, yes, I could say that approximately 3 skin cells would make 21 picograms in this sample, but again, it is true that I can't say that the DNA on this bag came from skin cells. It could have been another form of DNA.
Right, but all cells that you use are basically, on human cells, are the same size, correct?
Correct.
So it doesn't even matter if she sneezed, it's still only 3 cells, right?
Approximately, yes.
But when this was tested, it came to you as touch DNA, didn't it?
That's how the forensic biology described it in their paperwork.
And you.
I don't have that in front of me.
Right, but if that's how they describe it, you don't change it when you get it, right? Unless you test for some kind of different substance, right?
Correct.
Okay.
I just tested.
Well, Attorney Schoenhorn, it's about 2 minutes before 1.
Yep.
Since an exhibit may be displayed, perhaps we should do that after the luncheon recess.
That'll be fine, Your Honor.
Ladies and gentlemen, we stand in our luncheon recess. We resume at 2 o'clock. Please do not discuss the case.
Judge, good afternoon.
Good afternoon.
Just before we bring in the jury, I just wanted to be heard on one matter.
Yes.
Attorney Schoenhorn, just before the break, provided me with a disc. I believe it is defense W is in whiskey. And I had an opportunity to view it at the break, and I wanted to be heard on 2 quick things. One is that there are 2, for lack of a better term, conversion scales on this particular disc. One of which is entitled DNA sample on CSP exhibit 502, black trash bag. Now, I indicated to Attorney Schoenhorn that I believe that that title was misleading because there were 7 separate swabs taken of that particular trash bag, or 6 separate swabs that were taken of that particular trash bag. And this conversion scale only deals with swab 88.3S7. So Attorney Schoenhorn indicated to me that he would alert the members through the witness that in fact this only pertains to 88.3S7 and not the other swabbings that were done on that particular bag. So with that caveat, I don't have an objection. But however, with respect to the other conversion scale, I'll just show the court here. There's a conversion from 1 gram to ounces and a conversion from 1,000 milligrams to 1 gram. And I had an opportunity to speak with Ms. Maydell at lunch, and she indicates that the laboratory does not do those types of conversions. They do not use those types of measurements when they're doing their analysis. So my objection is essentially to relevance at this point, because if the laboratory doesn't do that type of measurement or conversion, then I don't see how it's at all relevant to the testimony. It seems to me to be argument to the jury that this is such a small amount of DNA and they're trying to make it relatable to the jury, but I don't think that that's appropriate with such scientific evidence. So I do have an objection to those 2 particular line items. There's 2 additional line items in which the laboratory actually does do the conversion. I have no objection to those.
Your Honor, Your Honor just has to, if you would put up that metric one, please. This is 6th grade math. How many milligrams in a gram? How many nanograms in a milligram? This is what I'm planning on offering. The court could take judicial notice of this. Whether the lab does this or not, it's just to illustrate what we're talking about. You start with a gram and how much that is equals an ounce, but then there's 1,000 milligrams in 1 gram. There's 1,000,000 nanograms in 1 milligram and 1,000 picograms in 1 nanogram. That's how you come up with a trillion grams in 1 trillion picograms in 1 gram. So I'm not sure I understand the objection whether the lab does this or not. This is 6th grade math. So I just want the jury to be able to understand when we're talking about minuscule size. That's solely what this is.
Well, the court understands that what the offer is essentially closing argument. There has been no testimony concerning conversion of picograms and nanograms into the lay terms that are commonly used, ounces or whatever other lay term that's common to society. So there's been no evidence that this expert has even touched on lay explanations in the form of conversions from picograms and nanograms to ounces. That's closing argument.
Well, with all due respect, Your Honor, I shouldn't have to call a math professor or a 6th grade math teacher. I'm asking for a little bit of latitude because the court could take judicial notice. These are undisputed facts of how much is within the next, how many grams are, or how big a gram is compared to an ounce, which the jury would then be able to understand. To suggest, though, that I have to get someone, I'll call the head of the lab. I will have the head of the lab come in here just to talk about these. This isn't even about the case. This is the standard math of how many grams, how many nanograms there are, how many picograms there are in a gram. I don't even see how this is even in dispute. So to suggest there's been no evidence of it, this is the kind of thing that a court can take judicial notice of, and there'd be no reason not to suggest I have to go now and find a math professor to come and testify and let the jury know how large that is. Just seems to be kind of a waste.
Counsel, if you are concerned about the conversion, your cross-examination is open to the following questions. How many picograms are there in an ounce? And you're left with your answer. How many nanograms are there in an ounce? And you're left with your answer. So as far as the relevance objection, that's sustained. Those questions are not foreclosed on cross.
All right.
Are we ready for the jury?
So Judge, just with respect to the disc, I don't know if Attorney Schoenhorn is planning on creating a new disc, or perhaps just keeping that for ID and creating a new disc.
We'll keep that that particular chart for ID, and I will replace this and remove the metric chart from the, but I would like it at least, Your Honor, is I'll replace this disk W with an X, which does not have that particular item on it. But what I'll also do is print a copy of just that one diagram or make it W-1, so it's just part of the record that it's what I was seeking to put in. So I just have a moment for that. And for now, I will not show that item to the jurors. The rest of it will be admitted then as W.
Yeah, I have no objection to the balance of the disc, Judge.
So defense W, which is the amended
This would be then, this is
conversion chart.
the conversion charges would be only for ID. So that'll be W-1. And then for the, we will then submit an X. That would be missing that, no microphone. We'll then submit X, exhibit X, which is not including that document. So therefore, that would be admitted as full. But for
So
now,
what the court will do is admit X when the jury is in.
okay.
Are we ready for the jury?
Yes, sir. Yes, Judge.
Mr. Marshall, there's no need for the audience to rise when the jury comes in. Counsel stipulate, please.
Yes, Judge. Before I move on, I'm just going to show you a couple of documents related to what we just talked about before the break, all right? And that would be in Exhibit X. Could you just pull up the item which has the bag, please? Description. All right, so this is just a written version of what we talked about, and I want to clarify that when we're talking about Exhibit 502 from the police, this was what you tested as sample 88-3S7, correct?
Correct.
And this includes the material that we talked about, that if a 0.420 nanogram, that equals 420 picograms, correct?
Correct.
And that 5% of 420 is the number is 21 picograms, correct?
Correct.
And that you already indicated is approximately 3 human skin cells, right?
Approximately, yes.
And therefore, to do that math, that would be the equivalent of 21 trillionths of 1 gram, correct?
Correct.
And do you know how many milligrams there are in a gram?
1,000.
And how many nanograms are there in a gram?
1 million nano. You said nano to gram.
Nano to grams, yeah.
Nano to gram is really. I'm sorry. I'm
It's all right, I don't want to, can you do nanograms to milligrams?
nanograms to milligrams is 100. 100,000.
Okay, and how many picograms again in 1 nanogram?
Pico and 1 nanogram is 1,000.
1,000 into 1 nanogram.
1,000 picograms, yes.
Okay, so it's pretty small.
Very small, yes.
I also wanted to, you testified before about the fabric cut from the seats that had been provided to you, correct?
Yes.
Now, you didn't do the cutting of the seat yourself, did you?
No,
Someone else did that.
correct.
And I'm going to, again, show you from Exhibit W, I believe. Now, your initials are over there up on the right above the initials of someone else, correct?
Correct.
Just want to highlight. Those are your initials right there, correct?
Correct.
So you would receive this blood and touch evidence examination worksheet from the biology people, correct?
Correct.
And you recognize the examiner's initials, CMR, that's Christine M. Roy, right?
Yes.
And the description, would you just describe what the description is of the item that you had received?
That she had received.
Yes, that she had received.
Next to submission, it says 86 envelope with parentheses 1 cutting upholstery fabric with BLS. Number 207.
Number 207, right?
Yes.
And then what was the description as as Ms. Roy described it here?
1 cutting of black upholstery type fabric with foam backing, area on black side circled, packaging label, quote, KM positive, luminol positive, end quote.
All right, so if we could go down to the bottom of to the last page of this exhibit for a moment. It's 3 or 4 pages. I just want to, this is the envelope that it came in.
Yes, that is looks like the back side.
All right, you go up 1, please, to the front of the envelope, please. If you'd zoom in a little bit. So is this how it arrived in the laboratory with these markings on it?
Yes, the bottom sticker would be what the PD put on it, and the top sticker with the DSS number is what we add to that package.
Oh, okay. And so when we're talking about what you just read, the description was on the envelope when it was received, correct?
In evidence receiving, yes.
And that was from Detective Riley from Western District Headquarters, correct? Garage?
Seized by Detective Riley is what it says, yes.
And it says seat back, right?
Yes,
Okay. And up at the top, it was described as a cutting upholstery fabric, correct?
correct.
And you were shown a picture of a seat before, right? From which the cutting came from, or no?
Again, I didn't look behind me when he put the pictures up.
Okay, so if you would just go back to the first page of this document, and you just go down to the middle part here. So you know that there was a black side of the cutting, right? And there was a notation here. It said no stained noted, correct?
That's what it says, yes.
And although other people have testified to this, it says NT, that means no testing was done, correct?
Correct.
But on the other hand, they developed at least a sample to send to you, 86S1, right?
Well, the no testing was for the KM or OTOL.
Right.
Yes,
Okay. And I just want to be clear, the back side of this cutting, right, mentioned a faint brownish stain, right?
that's what it says, yes.
And it said foam, that was the foam side, right?
Yep.
Now, did you actually have in your possession this cutting from the seat?
No, all I received was the swabbing she did that was designated 86S1.
And in any event, it also indicated that there was no testing and no, what did the NC stand for again?
Not collected
Nothing was collected. That means from that,
from that back side, the foam
right.
side.
but she did a swab and sent it to you, correct?
Correct.
And you did say that there was a finding of DNA that was consistent with, you talk about the toothbrush, but consistent with the DNA of the person that has been identified as Jennifer Dulos, correct?
Correct.
Okay. But you don't know how that that DNA was found on that seed, do you?
How that DNA was,
Got on this, let me rephrase the question. You don't know how that DNA was found on that cutting, do you?
It's going to object, Your Honor, to the form of the question. It's vague.
Well, the court understands the question as, this is how the court understands the question. You don't know how it was deposited.
Yeah, that's a better way to put it.
yes, that is correct. I do not know how the DNA got into that seed.
And to your knowledge, there was no confirmatory testing done on this swab at all, correct, on this sample?
Correct. From that worksheet right there, no confirmatory tests were done.
So you don't know whether or not the DNA that was deposited came from epidural cells, right?
I do not know where that DNA came from, no.
Or for that matter, whether it was from a fluid source of the person or skin cells, right? You don't know.
That is correct. I do not know.
Now, with regard to the, let me just ask you a couple more questions. And by the way, just because the police identify something as a BLS or a blood-like stain, unless it's testified as being, or at least it's tested for human blood, you're not able to even confirm what the police are calling it, right?
That is correct. Unless a confirmatory test for human blood was done, I can't say that it's actually blood.
Okay. I want to just go back for a second to the your testimony before about the trash bag and your testing of the sample that was 88-3S7. Okay. And when I asked you a little bit a while ago, or maybe it was this morning, you had indicated there were 4 contributors. I'm just going back to recall that, right?
Correct.
You were asked a hypothetical based on assuming whether or not, if Ms. Troconis had indicated in an interview that she had held a bag open while Mr. Dulos or someone else deposited items into a garbage bag, would that be consistent with how you might find some DNA cells on the exterior of that bag?
I object, Your Honor. Misstates my hypothetical.
Well, of course, the hypothetical, according to the code, the hypothetical in the first instance has to include facts that have a fair and true relationship to the facts of the case and to each other. Secondly, not misleading. And third, that the hypothetical is not so lacking in essential facts that it is of no value to the jury. As the court remembers the hypothetical that was posed, it was fairly short on facts. So the court is not able to determine whether it misstates the hypothetical.
If I could just be heard, Your Honor, on that.
Yes.
Attorney stated in his paraphrasing of my question that I indicated or someone else deposited something into the bag. I did not say that. So that was my objection, is he's injecting a third person into my hypothetical that did not exist.
Well, if I did, then I misspoke. I don't believe I did, but I will rephrase.
Thank you.
Again, as the preliminary, you recall you were asked a hypothetical about a statement that my client had made to a third party regarding holding a garbage bag, while Mr. Doulos put something in that bag. Do you recall that hypothetical?
I do, yes.
So I'm just going to add a few facts and ask whether or not this is consistent with that same scenario. Could the small amount of DNA have gotten on the bag if it had been, so for example, the bag had been moved from one room to another?
Well, I'm going
Well-
to object, Judge.
Well, first, the easiest way for the jury and the court to understand hypothetical, if it is in a classical form. In other words, we will ask you to assume certain facts. And then those facts are laid out as they have already come into evidence. And then there are additional facts that now give form to the hypothetical. But a one-question hypothetical is not in the form that this court sees as of value to the jury in making a determination. The whole scenario would have to be set out according to the code, right? And the classical approach to hypotheticals.
Would assume for a minute that a person took a garbage bag out of a roll, pulled one out, and then used their hand to prevent the next one from being pulled out?
I object, Your Honor. There's no foundation for this hypothetical.
Well, this is not a hypothetical, as the court hears it.
No.
Then the terms were used, assume for a moment, but this does not sound like a hypothetical. This is just simply an opinion about a certain scenario.
And I would just add, Your Honor, my objection on relevance grounds is there's no foundation for this particular assumption.
Well, again, that can be left to redirect examination, and the court will overrule the objection.
Again, if you start with what Mr. McGinnis had given an assumption, if a person were to pull a garbage bag out of a roll and put their hand to prevent the next one from pulling out, so you pull off one, would that scenario be consistent with leaving some DNA on the next bag?
If your bare hand is coming in contact with an item, yes, it's possible that you can leave DNA behind.
By the way, did you do any comparison, the DNA profile of Ms. Troconis's daughter?
No, there is no daughter submitted to the lab.
Did you do any testing with regard in comparison with regard to Ms. Troconis's mother?
No.
Would the handling a garbage bag while cleaning inside a house be consistent with depositing some skin cells or some DNA on a garbage bag exterior?
I object, Your Honor. Relevance, no
Wow.
foundation.
Well, the court hears the question as having already been answered through the first opinion given by Ms. Maydell, that if one bag was pulled from the box and another bag was held in the box by one of the subject's digits, could that possibly leave a DNA sample on that second bag? This is simply another scenario concerning how DNA can be deposited. The court is going to allow it. However, the court has already heard the evidence as to how DNA could be deposited, and the jury has already heard, on a bag coming from a box containing garbage bag. The court will allow the question overruled.
Sorry, can you repeat the question? Which scenario is this?
I have to say, could I ask that it be replayed? I forgot the question, I'm sorry.
Handling a garbage bag of pee inside a house is consistent with depositing some skin cells or some DNA on a bag.
Again, same answer if you're, oh,
Hold on, are you
sorry.
ready?
Oh, yes.
Oh, I'm sorry.
Same answer if your bare hand comes in contact with an object or item, there's a chance that you could leave some of your DNA or skin cells behind, yes.
And if you place cleaning supplies or even wipes or paper towel inside a bag by holding the neck of it or a portion of it with your hand, put something inside, would that be consistent with distributing some DNA on the exterior neck of that bag?
Judge, I object. Firstly, I think this question has been asked and answered at this point. The concept has been addressed. That's my first objection. My second objection is, again, there is no foundation for these so-called assumptions or hypotheticals that counsel is giving.
Well, this is not a hypothetical. This is the same question, but moving around the house. So at this point, it may be relevant, but under the code, it's now needless presentation of cumulative evidence. On that basis, it's sustained.
You talked about the last time you were here, the idea of transfer DNA. You could touch someone's hand, and that could also lead to transference of some amount of DNA onto a third object, correct?
That is possible, but many factors contribute to that, yes.
So just assume for a moment that if Ms. Troconis was in a truck with another contributor such as Mr. Doulos, touching either the seat or the hand of Mr. Doulos, and then he were to then deposit a garbage bag into a receptacle, would that also be consistent with a manner in which that her DNA could be transferred to the exterior of such bag?
I object, Your Honor. There is no foundation at all for this hypothetical, and counsel is attempting to engage in essentially closing arguments to jury through a lengthy question that bears no factual relationship to the record.
Well, there's already evidence that the defendant and Fotis Doulos were in the Raptor. There's already evidence that bags were deposited in trash receptacles. The hypothetical here in this court's view is sufficient for essentially the jury to make a determination based on the expert's opinion overruled.
So that's an example of secondary transfer, and secondary transfer can occur. Just so many factors contribute to that. We don't know if the person is a shedder. That makes a big difference for that initial transfer of DNA. If you transfer more DNA to someone's hand, then there's a better chance that that DNA will then transfer to that other object. And with each subsequent transfer, you're losing that initial DNA that you started with.
And you sometimes talk about a major and a minor contributor. Would you agree that looking at the deconvolution report in this case, that the 5% that was deconvoluted to Michelle Troconis would be a minor contributor compared to the, I think, 45 or 50% of Fotis Doulos in that same swab? Excuse me.
Yes, that is accurate.
Excuse me. I want to shift gears and talk a little bit about mitochondrial DNA. And according to what you testified, if I understood it correctly, mitochondrial DNA is found at least in hair roots. Is that correct?
Hair shafts.
Hair shafts.
I mean, it could be found in the root also because it's found in the cell, but not in the nuclear part of the cell. It's found in the cytoplasm, the white part of if you're thinking of an egg. The mitochondrial organelles have the mitochondria within those.
It comes from you called it the maternal lineage, correct?
Maternal line, yes.
And the maternal line means the mother side of the family, right?
Correct, yes.
So it's an X chromosome, but no Y chromosome, right?
No, it's not. The X chromosome is in the nucleus. This is separate. It's the DNA that's in the mitochondria. It's an organelle.
But the DNA, at least to the extent that it's comparable, the DNA in the mitochondrial cell is comparable to what's in a nucleus, only less. Is that a fair statement?
It's not unique to an individual, the DNA in mitochondria.
There are more people that can have that same mitochondrial profile, is what you're saying, correct?
Yes.
And I think you used some percentages, but which I'm not going to go into right now, but I think you said something like, if we're talking about Caucasians, you said it was 0.36% of Caucasians had that particular profile.
I mean, I have to refer to my report and which
Sure.
hair you're talking about.
Mhm.
So which hair are you talking about?
88-1-1S2-1.
Yes, in the Caucasian population, I wouldn't expect to see this profile. I would expect to see this profile in 0.36% of the Caucasian population.
So that's 3/3600ths%, right?
Mhm.
That's a yes?
Yes, sorry.
Okay. So less than 1%.
Yes,
You tested, and this is a hair that the report showed was found on a green and yellow scrubbing sponge, correct?
I'd have to refer back to the parent item, what 88 is, 88-1-1S2. Sorry, I can't find the parent item in the regular DNA reports.
Try looking at, oh, that's not it.
Yes, it's a sponge. It must be removed from a sponge.
12, right, I think. Is your report?
For 88-1-1S2?
88-1-1S2-01.
Yeah.
Yeah, it came from a green and yellow sponge, correct? And that was the one found inside one of the black garbage bags, correct?
Yes, I believe 88 was a black garbage bag.
And it was found, I don't know if your notes indicate this, but there's been testimony, it's found by the latent print examiner, the fingerprint individual who testified inside one of those bags.
I'm not aware of the latent print finding.
Okay. But in any event, you did the hair analysis using the mitochondrial DNA to make a determination, correct?
Yes, I did mitochondrial DNA testing and developed a sequence, yes.
You don't know how that hair got on that scrub green and yellow sponge, do you?
I do not know.
But you indicated that Pavel Gumieni could not be excluded from being the source of that DNA, correct?
Or anybody in his maternal line, yes.
Which means, when you say it could have been his mother,
Yep, mother, siblings,
siblings,
children. Not his
Well,
children, sorry, not
what'd you
his
say?
children. Nope, his mother or his siblings, yes.
right? Couldn't be his child because
No,
it's
he's
coming
mi-
from his side of the family. It would
Yes.
only be from the mother's side of the family, right?
Correct, yes.
Okay. And you indicated, as I understand it, that the full mitochondrial profile, DNA profile for Pavel Gumieni was the same as that of the hair that was on that yellow and green sponge, right?
Correct, yes.
I want to ask you just a couple of questions about the blouse and the other item, the bra that was examined, the DNA that you extracted from that particular item or those two items. You indicated, did you not, that there was a mixture of two contributors, correct?
And which item are you referring to?
The blouse, striped blouse.
41 1S1?
Yeah.
Yes, 2 contributors.
One of them you identified as being consistent with actually full included the source being the person we know to be Jennifer Dulos, correct?
Yes, the toothbrush cannot be eliminated.
Cannot be eliminated as the source.
But yes, but with 100 billion times more likely as the statistic.
And same thing with the other item of clothing, the brassiere.
What number item is that?
So right around that same number, I don't know, 40,
41 2S1?
yes.
That was a portion of British brown stain from the bra, and that was a mixture of 2 contributors.
Also two contributors.
Yes,
And one of them being the person whose profile was obtained from the toothbrush, correct?
correct,
And that would
yes.
be Jennifer Dulos as we know it,
Yes,
you know the name, right?
yes.
Did you test to determine who the second contributor was on these items?
I believe everybody that was compared was eliminated, but I
Was excluded, eliminated as being the source, right?
as being a contributor.
Did you ever determine who that second contributor to those items was?
Not from any more, no more knowns were submitted, no.
Did you ever, were you ever asked to compare it to an individual by the name of Kent Mawini?
No, I did not have his known submitted to the lab.
I just have a moment. I have nothing further. Thank you.
Redirect, please.
Ms. Nadel, you were asked questions on cross-examination about 88-3S7. Do you recall those questions?
Yes,
So just to recap, there were 2 different statistics or analysis they did with respect to the defendant's known DNAs, one under the previous DNA kit and one under the more recent DNA kit. Is that correct?
Yes, there was 2 different reports with 2 different comparisons. Yes.
And both statistics are valid. Is that correct?
Correct. Yes.
So it is 780,000 times more likely that the defendant was a contributor on the bag that had Jennifer Dulos's DNA and duct tape. Is that correct?
Objection. First of all, this is leading. Second of all, it's misstatement of what her
Well,
findings
well,
are regarding likelihood
The
ratio.
court understands the findings to be in this form. Assuming a certain number of contributors is then X times more likely to have originated from a certain source of the profile generated from a certain swab and one unknown individual than from 2 unknown individuals. That's the form of the testimony. And the court is going to sustain the objection because the form, as explained by Ms. Maydell, was not quoted or followed.
Yes, Judge, I'll rephrase. With respect to 88-3S7, it was your conclusion that that profile consisted of 4 contributors, correct?
Yes.
And it is 780,000 times more likely that the defendant was a contributor to that particular profile with 3 unknown individuals as opposed to 4 unknown individuals. Is that correct?
That is correct. Yes.
And that bag had Jennifer Dulos's DNA and duct tape on the inside. Is that correct?
I would have to go back to see that duct tape was collected as an item.
I would direct you to 88-3S4. Exposed sticky sides of duct tape.
Yes, so that would have been inside parent item 88.
And Jennifer Dulos was also assuming 2 contributors, 100 billion times more likely to be a contributor to that exposed sticky side of duct tape, correct?
Your Honor, this is absolute leading. The witness already testified. We don't need Mr. McGinnis to repeating the answers. He can ask regular questions.
Well, the cross-examination covered these essentially likelihood ratio. So the objection is overruled.
Ms. Maydell, do you remember the question?
88-3S4, you wanted to know that the toothbrush was 100 billion times more likely.
Yeah, and actually, I'll use Mr. Schoenhorn's phrase. The toothbrush is really the person we know to be Jennifer Dulos.
Correct. Yes, that's what we're using for.
Okay. And what were the results with respect to 88-3S4, those exposed sticky sides of duct tape?
Yeah, that was 2 contributors and 100 billion times more likely that originated from the toothbrush to Jennifer Dulos and 1 unknown individual than 2 unknown individuals.
Incidentally, you were asked on cross-examination by Attorney Schoenhorn about the amount of DNA that was found on 88-3S7. In your experience doing this for, I think, over 20 years now, if I'm not mistaken, is it uncommon to have such small amounts of DNA?
No, we can develop DNA profiles or partial DNA profiles from very little amount of DNA with our new sensitive kits. So no, having 20, 30 picograms, we can develop some DNA profiles, yes.
And just for the jury's benefit, simply because a particular profile has a small amount of DNA, does that mean that the person who is likely to be a contributor to that profile didn't actually touch it?
Yeah, I can't tell how the DNA got there. All I can do is process the sample, develop the DNA profile, and then make comparisons to the known to see if the types are present in that evidentiary profile. I can never say how that DNA or when that DNA got on that item.
You were asked about 88-1. 1S2, 88-1-1S2,
The
which
hair.
was a hair found on a sponge. Do you recall that?
Yes.
And you were asked on cross-examination about whether or not Pavel Gumieni could be eliminated as the source of that particular hair. Do you recall those questions?
My conclusion is that he cannot be excluded as being the source or someone in his paternal line.
I want you to assume that someone had cleaned Mr. Gumieni's vehicle with that sponge. Is it possible that a hair from Mr. Gumieni, being that it's his vehicle, could have ended up on that sponge?
Objection, again, it's the same objection Mr. McGinnis made. There is no evidence that anyone cleaned his truck with that sponge. So there is not a basis for making that assumption or hypothetical or
Well,
foundation.
Of course, the court has to determine which facts bear a true and fair relationship to each other. And then it has to determine whether the additional facts are appropriate for the hypothetical. So at this point, based on that question, even though there is no evidence that that sponge was used to clean the door panel or any other area of the Tacoma, the hypothetical is fair, overruled.
Yes, it's known that you shed hairs constantly. So if you are driving around your car, it's likely that you're going to shed some hairs into your own car. And then if you are wiping something down, you'd pick that up onto that sponge or a towel or whatever you're wiping it with.
And I just had a chance to review the results briefly, and so this isn't an entirely fair question, but with the exception of that hair, which we just talked about, isn't it true that Mr. Gumieni was eliminated from every single profile from items recovered in Hartford?
Again, I'm going to object to the leading nature of the question, and I thought there were some inconclusive, so it's an improper
No,
question.
the court is not certain that this witness knows what items were recovered from Hartford, because this witness only knows what is in essentially the transmittal from biology. So the court will sustain the objection, but allow you to rephrase the question.
Earlier, I was reading a stipulation out loud with respect to where certain items were seized. You'll recall that.
Yes.
And there were certain items that were read out loud from the stipulation that were recovered in Hartford. And my question is with respect to those items, and I guess I can 50, 51, 54, 61, 62, 52, 53, 55, 88. 40, 41, 96, although no profiles were developed on 96. But for the items that you were able to develop profiles on, isn't it true that Mr. Gumieni was eliminated from every single profile?
There's eliminations or inconclusive, but no positive associations.
And you were asked about item 86S1 by Attorney Schoenhorn. That was the swabbing of the cutting taken from the Tacoma. Do you recall those questions?
Yes.
And you were asked on cross-examination whether or not any confirmatory blood testing had been done on that particular swabbing. I believe you indicated no, correct?
Correct.
Could you just indicate to the jury why no confirmatory testing was done in that particular case?
Well, I wasn't the one to examine the evidence, but for protocol purposes, since it came in labeled KM positive, we wouldn't repeat that screening test. And if the sample appeared to be limited, you wouldn't want to consume any of that sample and have a chance of taking away some of the DNA that we maybe developed from that profile by using it to just confirm that it's human blood.
And I think as Attorney Schoenhorn pointed out on cross-examination, some of these DNA samples can actually be incredibly small. Is that correct?
Yes, incredibly small.
And so each time you do a test on it, it actually destroys some of that potential profile, correct?
Or remove some of that sample that you would have for DNA if you use it for a different test, yes.
If I could just have a moment, Judge.
Yes.
Nothing further, Judge.
Whether the likelihood ratio was 250,000 to 1 on the retest in 2023 or 780,000 to 1, assuming 4 contributors, you're still talking about the same 3 human cells, correct?
Approximately 3 cells from the amount of DNA that I amplified, yes.
And I didn't ask you anything about the tape on 88-3S4, did I?
Well, that's not cross-examination.
Was there any findings with regard to 3S4 that Ms. Troconis's DNA could not be excluded? Or was she eliminated?
88.3S4?
Yeah, 88-3S4. That was asked by Mr. Troconis.
Michelle Troconis is eliminated as a contributor to that profile.
And you were asked a question about whether or not Mr. Gumieni's DNA was eliminated from, at least from all other Hartford-based searches. Do you remember that question that he just asked you?
Yes.
But it was inconclusive as to whether or not his DNA was on a doorknob down in New Canaan. Is that
Just
correct?
object, Judge. It's outside the scope.
Outside of the scope of staying.
No further questions.
Maydell, you may step down.
Judge, may we approach?
Yes. follow media about the case. Have a good evening.
All rise. This honorable Supreme Court now stands adjourned until tomorrow at 10 a.m.
we would hear our argument on the issue today concerning camera coverage of this case continuing, as well as the trial scheduled for March of 2024. So at this time, the court would note I have reviewed the briefs. I'll begin with the state's argument on the issue here. After that, I'll hear from the defense, Mr. Pryor, and then finally after that, Ms. Olson, if you'd like to make any argument on behalf of your clients, you can do that. Mr. Wood.
Your Honor, respectfully, I'd actually ask that we reverse that order. This is technically the defendant's motion, and then the interested party agrees with the defendant. The state is in a responsive posture. We'd ask to be able to go after them to be able to respond. That being said, if you want me to go first, I can go first. I just think that would be the appropriate manner to proceed in.
All right, and I don't mind switching the order given that. Mr. Pryor, your thoughts?
Well, Judge, my thoughts are simply this, is that unlike the change of venue, which was the prosecuting attorney trying to have a court reconsider a motion without any lawful authority, because in the venue, there is no lawful authority for them to hear a motion to reconsider. In this particular case, it was the court's own initiative that said that given the posture that they would do a motion to reconsider, and the court is well within its right to do that. In essence, what it is, Judge, is it's a first-time motion to allow cameras, and as such, I think that it's proper that the state go first and followed by the defense and Ms. Olson.
All right. Quite frankly, I'm not sure that the order matters that much in terms of how persuasive the arguments would be. I would note it was the court that raised the issue sua sponte in its order to review the issue given where we're at. Mr. Wood, I'll hear your argument at this point, and then I will hear the response from the others. I'll allow a rebuttal, however, after they've made their arguments. So if you'd like to present argument now, you can.
Very well, thank you, Your Honor. So the motion before the court is whether or not we allow live broadcasting or cameras into the courtroom. I want to start out, I understand these are adversarial proceedings. We do not, the state does not see the media in any way as an adversary. We are grateful for the media. We respect the media. There's a reason why the right to a free press is in our Constitution and one of the first things mentioned in the Bill of Rights. We understand they have an important role in preserving government transparency. They have an important role in informing the public. And so we do respect them. This argument is not at all about whether or not the media should be allowed in the courtroom. They should be allowed, and we're glad they're there. In terms of broadcasting, the trial, and the state at least is going to address broadcasting the trial and broadcasting any further pretrial hearings. We shouldn't fix what isn't broken. This court made a very good decision. I believe it was in September or October of and we think the court was correct when it made that decision. We think that that decision led to more professional proceedings and helped in preserving the rights to the parties, the rights of the parties to a fair trial. Again, we're not arguing that the media should not be allowed in the courtroom. In our brief, we talk about that. The right of the public and media is important in the courtroom. This specific issue is addressed in an Idaho Court Administrative Rule 45. This court has sole discretion over this matter. It's not even appealable by any of the parties. So the state has raised these issues several times. We actually raised this in the previous case before a preliminary hearing. Our concern, I'm going to talk quickly about pretrial hearings. Pretrial publicity can impede the ability of the parties to a fair and impartial trial. This cannot be denied, and it rose its head in the last trial. Individuals who had seen specific media programs were automatically cut from the jury. We expect that issue will be raised again. And while the state doesn't necessarily agree with a wholesale cutting those individuals out, we understand the concern of when someone has consumed too much media about a case, that it may make it difficult for them to render a fair and impartial verdict. And so in terms of at least pre-trial hearings from here until the trial, the state's biggest concern there, and this might be our biggest concern overall, is if any of those hearings deal with evidence that we will be discussing at trial. We believe that by broadcasting it, it makes it even more easy to consume by the public, by the mass public, and creates further issues when picking a jury. And again, we've already seen it. This isn't a hypothetical. It's happened. There's no reason to believe it won't happen again. Again, we're not saying the media shouldn't be allowed to report. They should. That's important. There is a difference between reporting, though, and the ability to live broadcast. And there's nothing in the law that states that they have to be able to live broadcast. In terms of trial, and I don't want to regurgitate everything that all the issues I raised in my briefing, there's a lot of people who are called to witnesses in this case who want nothing to do with it. They're not there because they want to be. They didn't get dragged into a triple murder, horrible case, a sordid case, because they wanted to be a part of it. And the state is concerned, and we think validly so, about the effect on witnesses of knowing their face is being plastered on TV for millions of people to see. It's already hard enough to get on a witness stand, be placed under oath, and then to be direct examined, to be cross-examined. Trial gets aggressive. And then to have that added pressure of knowing my next door neighbor can watch this. The people I go to church with can watch this. It's not conducive, especially in a case like this, with fair trial for either of the parties. We understand that the defendant has a different position on that. We believe strongly that having live broadcasting this trial only makes it more difficult to get to the truth of the matter. As stated before, we do not believe that visual broadcasting is necessary for a transparent and a public trial. We believe in an open and public trial. Transparency does not require mass publicity. And there's no rule, there's no law that says that it does. And I would note, and I put this in my brief, at the last trial, at Lori's trial, there was a lot of reporting, and it was minute by minute. I called it live tweeting. I don't know if there's a specific other phrase for that, but where multiple reporters in the courtroom or in the auxiliary room were able to live tweet, and that was great. I fully support that, and in as much as we are able to follow it, it appeared to be very accurate and timely. And so the public, the interested public, was able to follow by the minute what was happening in the trial. They didn't need to watch it. They still got that information. And again, as far as the state could tell, it was accurate information. It was a job well done by the individuals reporting on the case. And so not only that, there's a transcript. People can obtain the transcript. There was an audio recording that was provided at the end of each day. And so in terms of a transparent and public trial, we don't have to point cameras in people's faces for the trial to be open, transparent, and public. I would quickly note, the state is aware, many of the victims in this case feel differently than the state. I know there was news articles about that last time. We don't technically represent the victims. We respect them and their desires, and it's appropriate for the court to know they don't necessarily agree with us on this. And so if we keep the status quo, if we keep it where it's at, there's no risk of a non-public trial. There's no risk of a non-transparent trial. The state doesn't see an upside to bringing cameras into the courtroom. It worked well the last time. Again, we shouldn't fix what isn't broken. And I put this in my brief, and if the court decides to change its decision, we respectfully request a few things. We would ask, and this hasn't been an issue lately, and it wasn't an issue at the last trial, but just, I guess, preemptively, we would specifically request that no media microphones be placed at counsel's table, as took place in some of the other pretrial hearings. We believe that violates Idaho Court Administrative Rule 45C, or at least has a very grave ability to violate that rule. We would ask that the court consider alternatives to live visual broadcasting, such as still photography. And should the court allow visual broadcasting, we would ask that the court essentially retain tight control on that, at least while it's being done. As this court is aware, once video is made and public, the court loses any and all control by rule over what happens with it. But we would ask that the camera placement be limited. We think a good model would be Ms. Vallow or Ms. Daybell's sentencing, in which I believe there was a camera on the court and one camera pointing at the parties. There was no zooming in on attorneys, on witnesses, on victims. And so we would ask that if the court does change its decision, that it do so within that framework to maintain the fairness of the trial. Again, we do not believe that live broadcasting is necessary. Thank you.
All right, thank you for the argument, Mr. Wood. Mr. Pryor.
Judge, the primary reason for Mr. Daybell requesting the cameras is to allow his family to view the proceedings. They would like the opportunity to watch on TV and to see how the trial transpires, and those children that aren't going to be witnesses would like to be able to do that. It's extended family as well. That's our primary reason for doing that. I'm concerned about live streaming because that allows, in my opinion, less control. Cameras, in addition, in the courtroom, we lose a little bit of control as well. But I'd be more concerned about a cameraman who's, while this thing has been proceeding, has snapped 1,000 pictures of me and Chad while we're sitting here. That's a bigger concern for me than the actual cameras. We can't control what this cameraman's doing and the pictures he's taken. He's been snipping along, and I'm sure I'll be seeing them with Mr. Eaton's website later today or tomorrow. The court, however, can put some conditions on a live camera. And on a live camera, like Mr. Wood pointed out, and I wholeheartedly, and quite frankly, Mr. Wood, I agree almost with everything you say. He makes a good, valid argument, Judge. However, the overriding concern is that when our founding fathers started the process of deciding that there would be a public trial, we didn't have cameras. We didn't have ability to broadcast this. And the idea behind a public trial was that if you brought allegations against someone and they wanted to answer those allegations, they should be able to do that in a public forum. And the stay of media and the amount of attention, and and I do disagree with Mr. Wood. East Idaho has been saturated with media attention on this case, but the reality is this is a national case. It has garnered tremendous attention. And a public trial is just not limited to people coming from Fremont County to sit in the courtroom and watch the proceedings. And having sat through the entire trial of Lori Vallow and watched the entire proceeding, there were issues with the live feed. I'm opposed to the live feed. I just didn't think it worked. It wasn't pragmatic. It wasn't practical. I think that let's use the professionals who know how to do this. I don't like the idea of a camera being pointed in my face for what's going to end up being 8 to 10 weeks. I dislike even more a photographer taking pictures of me while we're sitting here. And I'd much rather have a cameraman with that. And Mr. Wood pointed out some of the restrictions that we could apply. And I agree with what he said. No mics at the tables. I guess if you have to point the camera at Mr. Daybell and I, go ahead, and Mr. Wood and his group as well, and at the witnesses. But part of the reason behind the public trial, Judge, is accountability. And that's a big overriding factor. And when you're talking about due process and people having a fair right to a public trial, accountability is important. And as much as I don't like the idea of being on live TV, national TV, and I don't like the idea of it at all, the reality is it keeps everybody honest. It keeps the system honest. It keeps the witnesses honest. It keeps everybody honest. And and I'll disagree with Mr. Wood in just this regard. The fact that you have a camera on you, the fact that people are watching this in the public, much like when our founding fathers, you had to answer questions in a public forum. That makes the system honest. And that really is what the driving force, Judge, is allow the public to see this in an honest way, be able to see the entire evidence, not what press releases that people are releasing, not what certain news media report. Let's allow the public to see this in a public way and allow what really is should be a public trial. And again, allowing Mr. Daybell's family to review the proceedings, you could imagine, Judge, that if they show up to court, they would be inundated, whether it was here or anybody else, with the media hounding them and the victims as well, and everybody else who's involved in this, allowing them people to watch this in a public setting. There's one caveat. By doing this in a public with live cameras, Judge, that does create a concern for whether or not witnesses are watching the proceedings. And I guess I don't know how the court would address that. And that's something the court does need to look at. That doesn't change my position that I believe it should be a public hearing with cameras, but controlling how witnesses are limited in watching the media, and maybe the prosecutors and I can work out something with all of our witnesses saying, absolutely no opportunities to view this. If the court allows us to be a public trial with cameras, it's going to have to be some sort of an order that advises all of the witnesses that they're not under any circumstances to review the proceedings or view the proceedings. So that is a concern of mine, but I still stick with our original position that we need to have cameras in the courtroom, Judge. Thank you, Your Honor.
All right, thank you, Mr. Pryor. Morning, Ms. Olson. I'll note now we'll hear argument from Attorney Wendy Olson, who's representing EastIdahoNews.com, the Idaho Statesman, Idaho Press Club, and States Newsroom, doing business as Idaho Capital Sun. Brief's been filed. The court's reviewed that, and if you'd like to present argument in support of your position, you can do so at this time.
Thank you, Your Honor. And thank you for allowing my clients to be heard this morning. As the court noted, the clients are 3 Idaho-based news entities, and then the Idaho Press Club, which is an association of journalists who work on a variety of First Amendment matters to ensure that they can have complete coverage of matters of important interest in the state of Idaho. Your Honor, the entities request the ability to have live audio and visual coverage of the proceedings in this case, consistent with Idaho Court Administrative Rule 45, in a way that will allow the defendant and the state to have their constitutional interests protected in a way that is designed to respect the privacy concerns of jurors and the sensitivities of witnesses, and to really observe the dignity of the courtroom. And I think, Your Honor, that the media entities that are before you here have done that in other cases, and they would want to work with the court on any restrictions the court thinks is important to maintain the dignity of the courtroom, to ensure that sensitive witnesses, maybe only their audio is heard at the time. They would want to work with the court to ensure that whatever guidelines the court imposes, that they would follow. But they think it's important to have cameras in the courtroom and have live audio visual coverage of the proceedings for several reasons. primarily among them, Your Honor, it's the point that Mr. Pryor touched on is that we are in an age now where visual coverage of just about every aspect of public life is there, where people really have the opportunity to see with their own eyes, not by sitting in a courtroom, but by sitting in their living rooms or sitting in their offices to watch those proceedings. The Kyle Rittenhouse trial had extensive coverage, TV coverage. Certainly the Derek Chauvin case did. That started out of COVID, but the judge after that realized the importance of having cameras in the courtroom. And then more recently, the Alex Murdaugh trial in South Carolina, where the coverage there was basically from the opening of the trial through the sentencings. And I think that the coverage in those cases showed how, with guidelines from the court, it allows the public to observe firsthand what goes on in the courtroom. I know the court indicated that you read our submittals, our pleadings. I would also ask the court to take particular note of Rebecca Boone's declaration, and where she talks about she's worked with Idaho courts, Idaho journalists, law school to try to improve coverage of our court system. We learn a lot in the public about the executive branch and the legislative branch, but less is known about the judicial branch and how it operates. And I think it's important for people to be able to see firsthand what happens in a trial, how is evidence presented. I think it's important to the point that Mr. Wood raised, that it's important for them to see the impact that participating in a trial demands from the people who participate in it. It is no doubt, Your Honor, that the criminal justice system, the system that I participated in for most of my legal career, is very hard on the participants. It demands a lot of people. It demands a lot of the lawyers, the court, of the jurors, of the witnesses, of the family members. And I think that covering the proceedings live will allow the public to understand that better, because it is still a relatively rare thing for people to have firsthand involvement in any aspect of court proceedings. I think secondly, Your Honor, why it would be important and helpful to the court to have live audio and visual coverage is it would reduce the demand, frankly, for space in the courtroom. It's my understanding that the attendance at this hearing by the public is less than in past hearings, and maybe that's because the court elected to broadcast this live through the YouTube channel that the courts have used. Certainly, that will help the court with security and with other administrative needs and getting the trial done in a way that is most efficient. And so we think for that reason as well, it would be important to have live audio and visual coverage of the proceedings. And finally, Your Honor, with respect to how that is done, again, the media organizations want to make sure that they are working with the court on all of those things. And I know that the proceedings are being done through the court's technology today, but I would invite the court to not do it that way at the trial if the court allows visual proceedings. And that's really for several reasons, Your Honor. First, it is because the journalists who are experienced camera operators, typically who will do the pool reporting, they have more sensitive cameras, better cameras, and more sensitive microphones. They could be placed, not at counsel table, but somewhere else if that is the court's direction. In addition, Your Honor, the court would not have to worry about whether or not there are any technical glitches if the cameras are being operated by the pool camera reporter. Of course, neither the parties, nor the court, nor the jurors, nor anybody would want to have interruptions during the proceedings because of some glitch in the technology. And then I think, Your Honor, again, with having the members of the press who are experts in operating their camera, they would work with the court to ensure that there isn't anything unnecessarily intrusive if they were the ones to operate the equipment, as was done, I think, at Ms. Vallow's sentencing. And so I think for all of those reasons, Your Honor, our clients would like to see the live audio and visual coverage of the proceedings. I well understand, too, both Mr. Pryor's and Mr. Wood's concerns about witnesses watching things that they should not watch before they testify. There's nothing sort of less comfortable as a prosecutor to know your witnesses have received outside information, and then that comes in at cross-examination. And of course, we want to make sure the jurors aren't watching the proceedings. With respect to the jurors, Your Honor, and them reading coverage of the case once they've been set, that's a concern in every trial. The court gives firm instructions about that. And I think as media has evolved, the court's instructions on those issues have had to change over time to include, for example, social media. I know in the federal courts, there's a social media instruction that's given all the time now about don't look at social media when you're a member of the jury. And this court can certainly craft instructions that would cover all of the concerns the court would have with respect to the jurors potentially watching anything that comes from the live audio and visual coverage of the trial. Of course, hopefully they wouldn't be watching while the trial was going on. And then, Your Honor, with respect to the witnesses, it really was incumbent upon the parties, and Mr. Pryor alluded to it, to speak to their witnesses and firmly instruct them not to watch and not to be influenced by any other evidence. It's no different than telling them don't talk to other witnesses about their testimony. It's important that their testimony be from their own independent recollection. And those are challenges that are present in every kind of case. And here they're even more so because of the prior trial of Ms. Daybell. And so we would ask the court that in considering those factors, do the things that the court and the parties typically do, which is to give very firm instructions. Thank you, Your Honor.
All right, I do have a few questions for you, Ms.
Sure.
Wilson. Reading through your brief, you go through some policy arguments about why it's important to have cameras in the courtroom for these proceedings. One of your captions is, it will help enhance the public's understanding of court proceedings and promote respect for the rule of law. I'll note in my background, I did some federal criminal defense work. I was a CJA attorney for about 15 years, and I believe you were the U.S. attorney for Idaho during the time I was CJA attorney. In the federal courts, they simply have a Rule 53 that there is no permitting of any photographs, any video at all in any federal proceeding. Is that your understanding of how the federal system works?
It absolutely is, Your Honor, and I'm cautiously optimistic that that rule will be changing some. I think it takes sort of a major case with a lot of public interest to move things that direction, and I suspect that the federal charges pending against Donald Trump and others, there is now a lot more just discussion in the media about changing that rule. One of the things we cited for the court was a poll about people wanting to see live coverage of oral arguments in the Supreme Court. I understand that appellate arguments are different animals from criminal trials, but I think the federal system is far behind the state system in terms of allowing coverage of what goes on in trials.
Okay, well, I want to understand that because Idaho leaves it at the discretion of the judge under Rule 45. Some other states want cameras in and have rules governing that. The entire federal system completely bans cameras, and there are high-profile, important criminal cases of great public interest occurring all the time in the federal system. Would you agree with that?
I agree, Your Honor.
And in all of those proceedings, there are never cameras because it's prohibited by federal rule. And so the policy arguments that the public is not going to have confidence in this case or an understanding of what's happening. I just wonder how that's squared with whatever policy drives the federal courts to just simply disallow cameras and take it out of the judge's hand. Don't you think, in fact, the public can still have that same type of confidence in the proceedings and understanding if they want to come and sit in and watch a trial as they do in any federal case?
Yes, Your Honor. I think certainly people who come and watch trials and see sort of firsthand what is going on, and we certainly had those in the federal, we had people who were just sort of trial watchers who would come and watch every trial, and particularly the ones that add a little bit more notoriety. And certainly those individuals well understood what was going on in the courtroom. Not everyone can do that. In every case, as Mr. Pryor has outlined here, the family members of Mr. Daybell are not able to travel to Boise for attend the trial, and I understand there's a motion pending to change that for now in Boise. And I think obviously the federal government is not always ahead on policy issues of state courts or state governments on anything. And I think, Your Honor, my understanding is the federal rule is largely driven by the federal judiciary and wanting to ensure there are no cameras in the courtroom. And I think that will be changing as well, Your Honor. I think we're in a day and age where it is just the case that people want to see it with their own eyes. And federal courts are behind the times on that. And so there's a lot more work that needs to be done by people in the federal system, whether it's judges or former U.S. attorneys or criminal defense attorneys, to be able to articulate what goes on in those criminal courts. And there just isn't that I don't think as good of an understanding. And I do think there have been concerns expressed about outcomes in criminal cases and what it means. And there's a lot less direct information available for people to base that on.
Well, Ms. Wilson, I really appreciate your comments on that. It's really interesting to hear your perspective, having been on both sides of state and federal litigation and this issue. Clearly, there are policies in place in our state courts that maybe are different than they are in the federal courts. So thank you for the well-briefed argument and your oral argument today.
And I thank you, Your Honor, for the opportunity to present argument and the opportunity to appear in Fremont County, which is a great courthouse. Thank you.
All right. Thank you, Ms. Olson. Mr. Wood, I will allow a rebuttal argument just from the state at this juncture based on the posture of the case and the comments you made at the beginning. If you have any rebuttal, it's not required, but if there's anything you'd like to add, I'll hear that now.
Just very briefly, and appreciate council's comments. Mr. Pryor did bring up a point that I put in the brief but did not bring up, but it is important to note. And Ms. Olson addressed it as well. And the state's position is by broadcasting a trial, it only makes it easier for potential witnesses to make a mistake of seeing something they shouldn't see, of hearing something they shouldn't hear. At the last trial, this issue came up with a few witnesses, and that was just the audio. The state sends out something with every subpoena. We communicate to every single witness, you're not to watch or listen to any of this trial. Sometimes things still happen, and then we have to deal with that in court, and it takes time away from the jury, it takes time away from litigating the case. A long trial. I don't know if it's true. I've heard that the preceding trial in this case was the longest criminal case in Idaho state history. I don't know if that's true, but I've heard that. But this will also be a very long trial. This will probably be a longer trial. Broadcasting that length of a trial, we just really run the risk, no matter what we say to witnesses, of people hearing things, seeing things they shouldn't. I know just a couple of things from Ms. Olson's comments. And I'm probably not going to, I probably didn't write this down exactly how she said it, but she mentioned that we live in a day and age of visual coverage of everyday life. I don't know that that's really an argument for broadcasting a trial. I don't know that that's a good thing. And we could probably spend hours talking about all the social implications of the fact that we live in a day and age where everything is televised or put on a computer or a phone, and there's videos of everything everybody does. I don't know that that's really an argument that we should contribute to that. I don't think it's a good thing. I don't think it's a good thing to turn everyday life into a circus. And I think that broadcasting, even if done responsibly and respectfully, will contribute to that. I just finally end on noting, she mentioned the Kyle Rittenhouse case. I brought this up the last time we litigated this. It's interesting because that judge said afterwards, and I quote, "I'm going to think long and hard about a live television trial again next time. I don't know. I've always been a firm believer in it because I think the people should be able to see what's going on. But when I see what's being done, it's really quite frightening." That was Judge Schroeder from the Kyle Rittenhouse case. My understanding is he said that in regards to the context of a jury bus being followed by reporters. And we're certainly not alleging that any of Ms. Olson's clients are going to do that. But the reality is by broadcasting, we absolutely will create more of this circus type environment, more of this reality TV environment, this true crime obsession. Again, we believe the media should be there. They should report. They have a right to be there, and the public has a right to have the media there. The public has a right to an open trial. We would ask the court to maintain its current order. We believe it was a good decision then, and all the reasons that it made that decision then still apply today. Thank you.
All right, thank you, Mr. Wood. All right, counsel, I've been considering the decision on this issue. I am prepared prepared to make a ruling today. However, I do want to take a quick recess to sort of gather my thoughts and prepare for the ruling on the motions. So we'll take a recess here for about 10 minutes or so, and then I'll come back on the bench with the ruling. Thank you. Please be seated. All right, we're back on the record on CR 22-21-1623. The court took under advisement briefly its ruling on the issue of a reconsideration of video and photographic coverage of this case, including the trial. A couple of notes the court will have in making this decision. The court has listened to arguments of the state requesting that we keep the case status quo. And I'll note we did conduct a trial in the Lori Vallow case, which was initially joined with this case, later severed and tried in Boise. During the process of those proceedings, in order to allow some additional access, the court did permit a broadcasting on a limited basis of that trial to two separate locations where the public could view outside of the courtroom. One was a location in Ada County in their courthouse, and then a second location in Rexburg, Idaho. And there were certain reasons for doing that, mainly the fact that venue was changed and the case was taken so far from this location where the home counties are. So that factored into the court's decision. This is now a trial of Mr. Daybell. One of the big concerns I had also for the initial trial was potentially tainting jurors for what I knew would be a second trial coming up if the entire proceedings were broadcast from the Lori Vallow trial, concluding that anyone who had watched that trial or portions of it would likely be unable to serve as a qualified juror in this case. The court has also heard the request from the defense and the rationale for allowing broadcasting of the proceedings, including trial, and the court's considered the briefing and arguments submitted by Ms. Olson for her various media clients who are requesting the ability to conduct broadcasting and photography of the trial during the proceedings. A few things I'll note. First of all, under Idaho Court Administrative Rule 45B, the court has the discretion to make this determination. That rule reads that the presiding judge may, at his or her discretion, limit, restrict, or prohibit audio, audio or visual coverage of any proceeding. And those decisions are not subject to appellate review. I am compelled by some of the arguments that a difficulty in moving a trial about 350 miles away from where we currently are certainly restricts access by certain individuals that wish to attend. The argument by Mr. Pryor that the defendant's family members like to see the proceedings is a compelling argument. I know from the last case also there are other individuals, family members of victims, family members of defendants, and others very interested in the case or connected to it, which were unable to attend because of the location. I'll note also that the court still has under advisement, and we'll hear argument later this morning about changing venue, but as I sit here to make this decision, we're currently scheduled for trial to occur again in Ada County in this case. In balancing out the requests here, the court is determined, or has made a determination that in order to provide adequate access, the court is going to permit that the trial be broadcast while it occurs with certain restrictions. First, the court is going to be in charge of all equipment and the broadcasting of that. I'm not going to allow that to be conducted by any third parties. The court has the equipment to do so. We did that in the previous trial when it was broadcast to those other locations. It worked well in all the reporting I got back from those that attended and those that ran the system. And with the equipment to do that and the court's own website, which provides an ability to stream it live from the State of Idaho Judiciary website, public is given free and unfettered access to view the proceedings that way. So with that in mind, the court won't allow any still photography, given that the matter will be broadcast on video through the court's own system. And in addressing some of the other concerns as it relates to any microphones placed by any media or third party, of course, those will not be allowed because the court's going to use its own equipment to broadcast the proceedings. And in addition, there were about the exclusionary rule, so witnesses who would be testifying not being allowed to view the proceedings before they testify. I'll note that was already a concern in the first trial with Ms. Ballo, and we had an affidavit that addressed that and required each witness to certify under oath that they had not viewed the proceedings, and did in fact run across a few witnesses who were not able to do that and took those matters up outside the jury. I think that system worked well to make sure that there was not any improper influence on testifying witnesses. So the court will, in the same method of allowing witnesses to testify only after they've been able to certify under oath that they haven't been tainted by viewing previous testimony. There will be some additional technical terms of how the court will allow the broadcasting, and those will be followed up on in a subsequent written order that I'll enter into the case before trial. Going forward with other pretrial hearings, the court will take those up on a case-by-case basis, but this will be the ruling for the trial and how publicity will be handled. So I have balanced out also the concern of certain witnesses who don't wish to be captured on recording forever, and I understand that, and I've had to balance that out. I'd note at the last proceeding, they were also photographed whether they wanted to be or not and out of the courthouse because it's a public area, and the media was pretty persistent in trying to capture images and pictures of them. So there's really not any way to completely prohibit that. And while that's unfortunate for those that do not enjoy being on camera or all the publicity, that's just part of the stress, I guess, of being involved in a case like this and having to testify. So the court is going to amend its current order as it relates to the case. And as I mentioned, I'll follow up with some additional detail in a written order, but I wanted the parties to be aware of where this would be heading as we get closer to trial. So that will be the court's ruling on the motion at this time. Mr. Wood, does the state have any questions on that ruling?
Not at this time, thank you.
Thank you. Mr. Pryor, any questions?
No, Your Honor.
Okay. And Ms. Olson, any comment or question? All right, thank you. That will conclude the first motion then. The next motion we will bring up, if the parties are ready to proceed, will be the state's motion to amend the indictment. This is a motion that the state filed on November 18th of 2023, and a response and objection was filed by Mr. Pryor on behalf of his client on November 17th, 2023, and the court's prepared now to hear argument on that. Who will be arguing on behalf of the state?
I will be arguing this one, Your Honor.
All right, Ms. Blake, are you ready to proceed with argument?
I am, Your Honor.
All right, you may go ahead.
Thank you. Idaho Criminal Rule 7E and Idaho Code 19-1420 are the governing authorities regarding amending indictments. Both of them make clear Idaho Code essentially reflects very similar language to the Idaho Criminal Rule 7E. It adds some additional language regarding prior to the plea being made by a defendant that an indictment or information may be amended. Since we're post the plea of not guilty, not focusing on that part of the section. But essentially both Idaho Criminal Rule and the Idaho Code allow that prior to the prosecution resting the case, an indictment or information may be amended so long as no additional charges are added and the defendant is not prejudiced by the change. We filed this motion approximately 6 months before what will be the start of the defendant's trial. So our position would be that the defendant is on adequate notice as to the request to modify the indictment. I would also indicate that for the benefit of counsel and the court, I did submit a proposed amended indictment with the changes italicized for the benefit of court and counsel to be able to observe those. That was submitted just by email, waiting to determine whether or not the amendments would be approved prior to submitting a new filing. There were three main amendments that the state is asking to modify. I will indicate they reflect the same modifications that were requested and granted in the co-defendant's trial. The first one is to modify the subsections referenced in counts 1 and counts 3. Those are the counts dealing with conspiracy to commit first-degree murder and grand theft. They are specifically dealing with the code sections referencing the grand theft. It would be a request to change it from 18-24034A to 24032A. The state's position on that is it actually is more reflective of the language contained within the current indictment, not specific to the defendant, but there was a charge of grand theft. That charge reflected the language regarding that the theft occurred by deception. When we look at the case law in Idaho, looking first to State v. Ghana, 117 Idaho 83, and that's an Idaho Court of Appeals case from 1989. It specifically outlines the purpose of the information is to allow defendant notice and opportunity to prepare a defense. And in State v. Bolus, 93 Idaho 749, that's a Supreme Court case from 1970. There was an amendment made changing the code section from one that described the differences between first and second degree burglary to the code section that defined the crime of burglary itself. And the court found that there was no issue with making that modification. The defendant wasn't prejudiced. The court found the defendant was always on notice that the underlying charge was burglary. In addition, when we look to State v. Dunn, that's 60 Idaho 568, again, a Supreme Court case from 1939. The court found there was no substantial difference to the charge of to whether or not the charge of obtaining money by false pretenses was that the defendant received or executed the contract. The court found the defendant was charged essentially with having fabricated the contract, regardless of the method in which that fabrication occurred. And again, they found that there was no substantial change. The defendant was properly on notice. There was no prejudice to the defendant. And then in State v. Severson, 147 Idaho 694, that's again an Idaho Supreme Court case, but from 2009. The court laid out the relevant factors to determining whether the defendant was prejudiced is whether it took the defendant by surprise, impaired defendant's ability to adequately prepare a defense, subjected the defendant to double jeopardy, or required extensive further preparation by the defendant in preparing for trial. In Severson specifically, the court found the amendment merely alleged an alternative way defendant may have committed the crime. None of the defendant's substantial rights were prejudiced. Essentially, in that case, the state added a theory that the victim in that case had died from suffocation. And the court found that that did not modify the charge itself. It didn't add a new charge, and the defendant was properly on notice with no prejudice. In this case, the state would say we're in a similar position. The requested amendment does not add a new charge. It simply modifies the subsection under which defendant is accused of having committed the crime. The defendant's properly on notice. In addition, the indictment contains language reflective of that subsection 2A. If anything, the state increases the burden by having to prove the crime was committed through some use of deceit versus simply that a theft itself occurred. That it was simply, we add that element of deceit. So if anything, it would incur burden. In addition to that, the state would indicate the actual charge isn't the grand theft itself, especially with regard to the defendant here today. The actual charge is conspiracy. It's just one of the elements is it incorporates the elements of the grand theft as part of that conspiracy. So we think that that is an appropriate amendment. We think we're doing it in plenty of time to give the defendant advance notice of that modification. In addition to the fact, one could argue the defendant was on notice during the course of the co-defendant's trial when the state made these modifications, knowing he was charged under that same indictment. So I think that if defendant is on adequate notice, there is no press, and there is no additional charge with that change. The next requested change would be for, I reference the correct counts.
On that last point, Ms. Blake, I'm not sure you could deem it notice where in the first case that the amendment occurred right before the state rested at the end of the case. And then knowing that this issue was in the indictment here, it's up to the state to make that amendment and change it. So I guess they could speculate that you were going to do that. Until such time as we're here, I don't think they're really on notice that that's happening until we argue it as we're doing today.
And I can appreciate that point. I guess the fact that it was amended would have at least given some indication that there could be the potential. I would agree the actual notice was not until the filing of the document. There had been some discussions amongst the state and defense counsel that we would be filing a motion to amend the indictment, but I would agree until the actual filing, it isn't considered official notice. But I think they were aware of that occurrence during the co-defendant's trial. Looking at counts 1, 3, and 5, the state is requesting to add the language and or between the co-defendants listed in that or the co-conspirators and or potential co-conspirators. The state's position similarly, we look under that same test, and the state's position is this clearly does not add a new charge, and we would also argue it does not prejudice the defendant. In addition to that argument, in State v. Yang, 167 Idaho 944, it's an Idaho Court of Appeals case from 2020. While it was a touch different because this was a case in which they were asking to modify a jury instruction to be given regarding the co-conspirators in the case versus amending an information or an indictment, the court found that adding the language and or was not a substantial change to the jury instruction. What the court essentially found is it is not incumbent on the state or necessary to prove the number of co-conspirators or the identity of each co-conspirator. It's simply that there was an agreement with at least one other person, and one of those parties committed an overt act in furtherance of the conspiracy. So knowing that those aren't officially elements of the case, I think looking at State v. Yang, that provides clarification and the guidance that this would be an appropriate modification. In addition to that, we are asking for this well in advance of trial to put the defendant on notice that we would be asking for that modification. I don't think that changes anything with regard to the elements of the crime or the burden required. And I think that has clearly been litigated in the courts here. The last one that the state had noted in the motion itself to amend the indictment was a change to count 5 and specifically overt act number 10. The state is asking to change the month to months with adding the S. Essentially, it was a typographical error, requesting that it be changed to the months before. And looking again at some of the cases we've cited to before, Ghana, the defendant had argued that he was not on proper notice because the state added a charge of persistent violator 3 weeks before trial. The court found that was sufficient notice in amending that 3 weeks before trial to add that. And then again, looking at the test outlined in Severson, the state's position is this does not add a new charge and it does not create any prejudice to the defendant. It is not a double jeopardy issue. It's not going to create any kind of extensive preparation by the defense or further preparation by the defense. In addition, the state would argue similarly that this modification was made during the co-defendant's trial. The defendant has been in possession of the discovery in relation to this case. The defendant has had the benefit of watching the co-defendant's trial and or listening to it, where it is clear that this was what was presented during the trial, was that it included the months. In the amended indictment sent to the court and counsel, there were a few other italicized proposed changes. Those were not specifically addressed in the motion. They're simply typographical errors or errors where certain language was left out. I could go through those, but essentially the state's position would be similar to what we just argued with the months. They're not adding new charges. There's no prejudice to the defendant. We're bringing them in advance of trial, requesting permission. The state does recognize that it is in the discretion of the court, once a plea has been entered by the defendant, whether or not a state is allowed to amend an indictment or information. However, both the rule and code make clear that before the prosecution has rests, that it is appropriate to bring the motion. So with that, the state would request that the court grant this motion to amend the indictment reflective of the changes sent to the court and counsel.
All right, one question, Ms. Blake, on some of the proposed amendments here. If you have it in front of you, the proposed amended indictment,
Yes.
page 6, there's common scheme or plan in Fremont is how it reads now, and it says Fremont and Madison counties.
Yes.
Do you want to address whether or not that would be permitted pursuant to the rule, or does that require any further findings by the grand jury?
I don't believe it requires any further findings by the grand jury for the reason that it was simply a typographical error and left out. When you read the count and the contents of it, it includes in the county of Fremont, state of Idaho, and elsewhere, including Madison County, Idaho, and as part of a continuing criminal transaction and common scheme or plan in Fremont counties. So, and Madison was simply left out of there. In the same body of that count itself, it includes Madison County already. So it was simply to correct the confusion that may be from Fremont and then having counties, and Madison was simply left out. But the rest of the indictment and the information presented included acts in both Fremont and Madison County, and that's what has always been purported and alleged by the state. So I would argue similarly, it modify anything. It doesn't prejudice, or excuse me, it doesn't modify it as far as a new charge, and it doesn't prejudice the defendant. I don't think it creates any kind of a venue or jurisdiction issue either, especially given what's in the body of the rest of the indictment. It would simply be to alleviate any confusion that may be seen there by having simply Fremont and then the plurality.
All right, thanks for the response on that. All right, the state submitted its argument in support of the motion. Mr. Pryor, if you'd like to present your argument in opposition, you may.
Judge, there's no doubt that the prosecuting attorney has a right to amend the indictment right up before the close of their case. And again, I was aware of some of these. I'm not going to argue the month or months. I think that's, given what they've represented, that's appropriate. In addition, in terms of the overt acts that they talk about, including the language of Madison County, I guess.
Could you just pull the mic a little closer there? Sorry, not picking up the recording.
That was not good.
Alternative, you can argue standing or from council table, either way.
Judge, in addition, I guess I could make an argument. Is that acceptable? The level of noise, sound?
It's still a little quiet, the clerk says.
That any better?
Yes.
I'll try to lean forward and talk that. Judge, I've never been accused of not having a loud voice, so this is new for me. And the court's smiling. Court's aware of that as well. Thank you. Judge, in regards to the Madison County, quite frankly, the state is right, and at least in this perspective, they're right. They allege in the actual body of the language that Madison County was above that, and about 2 lines above the change they're alleging. They actually mentioned Madison County. So for me to suggest that they can't do that, I think be improper. So I'll agree to them allowing that. There is an argument, I guess, in terms of bringing it back to the grand jury to make a representation about the venue, but I'm not going to engage in that today. However, what I am, Judge, going to engage in is the language on counts 1, 3, and 5. This is my concern. I understand the previous case. Ms. Blake represented, talked about that the and or was not a dramatic change in terms of what's represented. But the concern I have with this, Judge, is if you look at the actual indictment and look at the language, they're alleging that Lori Vallow and or Chad Daybell and or Alex Cox and or the other conspirators that were involved in this case. Now, to date, and there, we've dealt with this before, we have no idea who the names of these other conspirators are, or at least the state hasn't disclosed the other conspirators that were involved in this case. But the concern is that it shifts the burden, and it changes the burden that the state's going to have to prove. And how it does that is this, is that a jury who are not legally educated citizens are going to look at the indictment and say, well, under this particular allegation, we don't actually even need to prove Mr. Daybell did anything wrong. What we have to prove is that, well, it could have been Lori Vallow or Alex Cox or the other conspirators. Don't even need to prove Chad Daybell to find him guilty. All we have to do is that the others were involved in this. That's all that, and that kind of logical thinking can go towards what the jury would be thinking about this. And unfortunately, if that's what they want to do, then they need to take this back to the grand jury and have them approve this language and say, we're going to indict Mr. Daybell because and/or can be defined as meaning whether he could have done it, yeah, and he could have been there, or it could have been the others. But if it's just the others and not Mr. Daybell, we're still going to find him guilty because the amendments that the state is alleging in terms of count 1, count 3, and count 5, that sort of thinking can take place. And that is my concern. And it's confusing. And I know Mr. Archibald touched on this at the time, and the court allowed these changes to go forward. But my concern again is this, Judge, is that the plain reading of that language by including and/or between the unnamed co-conspirators that we don't know I don't know who the names are, Alex Cox, Lori Vallow, and Chad Daybell, the state put and/or on all of the names, changed that, and that in essence changes how the plain reading of that particular phrase could be interpreted. That is my concern. And it's enough of a concern, Judge, that technically you could look at this and say, Mr. Daybell could be found guilty of 1, 3, and 5 without having done anything, given that the others, or the others could have been involved and they could impute that onto Mr. Daybell. That's my concern. Lastly, I understand that they're alleging grand theft under 2403. My concern is that they alleged it in front of the grand jury under one particular section of 2403. They are now changing that to a different section under 2403. The case law is not clear at this point as to whether or not changing the underlying charge or any of the subsections, it doesn't address that. It does say that if you change the underlying charge, that could be problematic. It doesn't address whether changing the subsection and the level of proof that they're going to do, and I would concede to the state that it's not 6 months, Ms. Blake, it's 4 months before we start the trial, less than 4 months at this point. But I would concede, Judge, that if the court finds that just changing the subsection is not enough of a change, obviously I would accept the court's decision, but it is a different subsection under the grand theft charge, and it does require a different burden of proof. And the state saying that it's made it more difficult on them, I don't agree with that. What they've done is they've changed the subsection on what they're trying to get Mr. Daybell convicted of under the crime of grand theft to a different subsection. That is a change, no matter how you put it. Whether or not it's permissible, I'll leave that to the court's decision.
All right, thank you for the argument, Mr. Pryor. Ms. Blake, do you have any rebuttal argument?
Just briefly, Your Honor, as the state indicated with regard to the grand theft, the actual charge is conspiracy. And so I would indicate that again, as well as the cases previously cited, which do allow for, which have in the past allowed for amendments that change the theory of how a case or under which elements or theory presented under subsections the crime was committed doing. In addition to that, I think State v. Yang makes very clear that regarding a conspiracy, the state is not required to prove the number of co-conspirators, and they're not required to prove the identity of the co-conspirators. Again, a conspiracy, the state's burden would be to prove that there was a plan engaged in a common scheme or plan, and that at least one of the actors engaged in that plan committed an overt act. There is no requirement that every person engaged in a conspiracy commit an overt act. So I think to indicate that somehow others' actions may be imputed to Mr. Daybell. That probably is not a wrong assessment by the defense, that that's the nature of a conspiracy, is any one of the co-conspirators committing a bad act does in fact is one of the elements of a conspiracy. So I don't think in any way modifying the and or additional burden on the defendant, and in no way is it burden shifting. The state's requirements under conspiracy remain the same.
All right, thank you, Ms. Blake. All right, I'm prepared to make a ruling at this time on the motion. This is the state's motion to amend the indictment in this case. The court will note under Idaho Code 19-1420 that there reads amendment of indictment may be amended by the prosecuting attorney without leave of the court before a plea. We're after a plea here, so at any time thereafter in the discretion of the court where it can be done without prejudice to the substantial rights of the defendant. So that's the standard the court looks at contained in that statute. There are some clerical amendments being requested, and there are some substantive amendments being requested in the state's new proposed indictment. The court's looked at the case law on this issue. There's a case, State versus Jeske, 164 Idaho 862, and it's a 2019 case that says the decision to permit an amendment is a matter within the discretion of the trial court. And then that case also cites to a case, State versus Severson, 147 Idaho 694. The court may allow an amendment of an information, and in this case, an indictment would apply at any time before the prosecution rests, so long as doing so does not prejudice the defendant's substantial rights or charge the defendant with a different offense, and then citing to Criminal Rule 7 and Section 19-1420 that I just mentioned. So there's discretion here for the court to consider it, starting with the clerical corrections requested, and included among those the of the word Madison County on page 6. The court finds that the state's motion is permitted pursuant to Idaho Code 19-1420 on what I'll consider the proposed amendments that are clerical in nature. So the motion's granted on that. Going to the more substantive requests of the state, primarily on counts 1, 3, and 5, where there's a request to amend the stated statute under which grand theft by deception is contained in the indictment. Initially, it was listed as 2C, I believe, which is, or was it D? What was the initial, I know it's being changed to 2A if you have it amended, but what was the subsite that was in the initial indictment? I could pull it up.
We have it as 4A, Your Honor, that it was initially under 4A.
4A. Thank you for the direction there. The theft statute is kind of a large statute, but the request is that under 4A, which would be by possession of stolen property, it's to be amended to 2A, which was theft by deception. The court will note I did previously look at a similar request to amend in the prior case, and that's relevant here. And I'm talking about the Lori Vallow case, the 1624 case, because the indictment is the same between the cases and the parties here. So I noted then when I considered that at trial and allowed the amendment that the language of the indictment has read by deception, and it would comport with the offense under the 2403A under 2A to be theft by deception. I don't find that that constitutes a new charge or a different charge. The either grand jurors or trial jurors are not pulling out the code to read the code sites to see if that's what the offense is. They simply follow the instructions of the court that are provided that list out the elements of a crime. And the question here is whether or not Mr. Daybell was adequately put on notice of the theory of the state's offense as it relates to the theft part of this conspiracy charge. And because it was listed as theft by deception all along in the caption, and because also the language within those counts 1, 3, and 5 described theft by deception, the court does find that allowing the amendment to 2A more accurately describes the statute upon which the defendant is charged and does not constitute a new charge, nor does that result in a prejudice to the substantial rights. I'll allow the amendment then on those provisions, also noting that at this point, we are still in advance of trial, not real far in advance of trial, but enough in advance of trial that the defendant is adequately advised of what the charges are. I don't find that any of the proposed amendments either would require resubmission to the grand jury for a determination that probable cause was found on these offenses, and that this can be amended by motion, which the state has done today. Finally, I would also agree with the state's position here that on the and/or provisions, that the underlying offense as actually charged here is the conspiracy offense. And under conspiracy law, the state's burden here is to show a common scheme or plan as alleged in an overt act. And the case law, including the Yang case cited by Ms. Blake, permits the state to have alternatively listed co-conspirators following conspiracy law. And because it's charged as conspiracy on those counts, I also find that does not result in any new charge or a prejudice to the substantial rights of the defendant. So I find the motion to be timely at this point. The court will grant the motion to amend the indictment, and the proposed amended indictment as received by the court will be allowed to be filed in the case. And that will be the indictment that will instruct the jurors at trial. That'll be the court's ruling on the motion then. Ms. Blake, do you have any questions on that?
No, Your Honor.
Mr. Pryor, any
Oh,
questions?
Your Honor, thank you.
All right, thanks, counsel. The next motion before the court is the state's renewed motion to reconsider the change of venue. This motion was filed by the state on November 15th, 2023. The defendant filed their response and objection to the motion on November 17th, and this relates to the court's pending decision or current decision that the trial will be conducted in Ada County. Who's going to be arguing that motion today?
I will be, Your Honor.
All right, Ms. Blake, are you ready to proceed with argument on that?
Yes, Your Honor.
All right. Why don't we do this? Let's have a quick about 5-minute break in case there are anyone here that wishes to either use the restroom or leave before we proceed with the rest of the motions. So we'll take a quick recess and then come back on and start with the change of venue motion.
All rise.
Restroom. We are back on the record, case CR 22-21-1623, State of Idaho versus Chad Guy Daybell. We are scheduled next to hear a motion on the state's renewed motion to reconsider change of venue. Motion filed November 15th with an objection filed November 17th. I can't recall who was arguing this. Blake?
Yes, Your Honor.
Ms. Blake, if you'd like to present argument in support of the motion, you may.
Thank you, Your Honor. And the first thing the state wanted to address was, I think, in the defense's response, there had been an indication that motions to reconsider are inappropriate or not allowed. So I just wanted to go ahead and address that first. They are allowed under State v. Montague, 114 Idaho 319. That's an Idaho Court of Appeals case from 1988. The court makes clear that it is in the discretion of the court whether or not motions or requests for reconsideration are considered. Essentially, the court pointed out that because such a request is not specifically mentioned in the rules of criminal procedure, a trial court is not without power to act upon it, but essentially it would be within the trial court's discretion, which similarly do not contain any such motion, a rule regarding a motion or a request for reconsideration, and specifically found the federal courts have held that a trial court is free to entertain such a motion when made. And then essentially the Idaho court joined in that finding. In addition, State v. Wolf, it's 2013 APP Lexus 86, and that's an Idaho Court of Appeals case from 2013. In that case, there was a motion to reconsider a Rule 35. And similarly, the court looked to State v. Montague for guidance and found that a motion to reconsider can be allowed. And then they went through an analysis as to whether or not it was proper with the Rule 35. Ultimately, they found that it was proper, that it could be considered by a court, a motion to reconsider a Rule 35. In that case, it came down to a timing issue. I think a couple years had actually passed on some appellate issues that court was looking at, but the actual motion to reconsider was found to be appropriate. So I do think it's clearly established in the Idaho rules that a court is allowed and can consider a motion to reconsider. The courts go on to talk about, I believe it was State v. Montague. It may have been Wolf. I apologize. I should have had notes about that. But essentially, they talked about that there were some additional facts and considerations that were brought forward for the court to consider. I think it was in Montague, and it was regarding some evidence that was not presented at a motion to suppress by the state, but that the state had in its possession. So they had asked for a motion to reconsider and present that evidence. The appellate court found absolutely the court could consider that. They did kind of admonish and say maybe the state should have brought that the first go round, but where it was new information not previously presented to the court, they found it was absolutely appropriate for that court to reconsider. The reason I bring that up is I think we find ourselves in a similar situation. However, this information was not within the state's possession at the time the original motion for change of venue was brought forward. But we are in a new situation with the passage of time, as well as new media coverage and heightened media coverage in Ada County. So
Before we go into the merits of the motion, then I'll make a comment on that, on the reconsideration, because I think there's some inconsistency in the Idaho case law, because I'm aware of other cases. I know of one in particular that, and I don't have the cite off the top of my head, but I've used it on many occasions with attorneys in criminal cases that says, unlike the civil rules and the Idaho criminal rules, there is no motion to reconsider. That being said, I do think that within the court's discretion, at times, there are certain types of motions that merit reconsideration, motions that develop additional evidence, motions in limine, et cetera. This particular motion, as it relates to a request to reconsider the change of venue, I would find appropriate. So despite potentially conflicting case law on that, I think it's procedurally proper to bring the motion. And so I'm just saying, don't be concerned about a ruling based on you can't reconsider this, because I think in this case it can and should be reconsidered. So with that in mind, if you'd like to go into the merits of the argument, you can.
thank you, Your Honor. And I appreciate that clarification from the court that there is case law disputing that. I had found the cases that specifically allowed for it. So looking at the merits of the motion itself, where the state believes that we are at is there are a couple different rules that govern requesting for change of venue. The state does not believe that we are in a position of actually requesting a change of venue. That was done by the defendant, and Idaho Code 1801 specifically says the defendant can request a change of venue if they feel that there would be bias or prejudice or an issue with holding it in the actual venue where the crime is alleged to have occurred. In this case, there's no question that Fremont County is the originating venue and the appropriate venue. The defense brought a motion back in, well, it was ruled on in October of 2021. It was filed before that. So it was ruled on quite some time ago. I know the state had done a motion, essentially kind of a hybrid motion to reconsider and also to consider bringing in a jury. So reconsidering some of the findings made with that order. However, now there has been a significant longer passage of time, in addition to the fact, of course, the biggest change was the defendant essentially demanded a severance, requested the severance, and was granted that severance. After that severance was granted, the co-defendant, Lori Vallow, opted to proceed with her trial in Ada County. And the reason I say opted to proceed is, as the court probably recalls, it was actually the defendant that brought the original motion to change venue and was granted the change of venue to Ada County. However, at that time, the cases were still joined for trial. And when Ms. Vallow was found competent and her case also started moving forward, the indication from her and her counsel were they were fine with the change of venue. They were in favor of it, essentially. And they never requested anything different. So we proceeded with her trial. That started the end of March of this year and proceeded into mid-May. So, and as the defense points out, some of the timing and reference in some of these motions is off, given the hearing date versus when they were filed and when the initial drafting was started as well. But we are now less than a year from when that all occurred. During that trial, there was daily coverage. I know that's been covered in part in the motion to allow cameras back in the courtroom that was argued today by the parties. A lot of that was already referenced. There were daily reports coming out. There were interviews being conducted on the courthouse steps daily throughout the trial. Those interviews included comments on evidence that was presented, opinions on the credibility of witnesses, opinions on the culpability of the defendant and the co-defendant. I know there were some references made regarding Chad Daybell during that time as well. So with that, we just think based on the original argument made by the defendant that he thought the coverage was too pervasive here in the 7th Judicial District and specifically Fremont County, we now find ourselves in essentially that same position, but in reverse. The coverage in Ada County has been very pervasive. The state does recognize when we look at the numbers, the coverage in the 7th Judicial District as a whole and Ada County area as a whole is very similar. Ada County numbers tend to come in a little bit higher, but we recognize the coverage is still broad in both areas. However, we would indicate that at the original change of venue, there were no specific findings made with regard to Fremont County. Fremont County was clustered into the 7th Judicial District, and in part that dealt with a witness for the defense that ultimately any testimony regarding Fremont County ended up being excluded because enough people weren't polled to make accurate or sufficient findings regarding the pervasiveness in Fremont County. Some of the other things looked to were the vigils and things that had gone on in relation to this case here in Fremont County. At the time the order had come out, it would have been approximately 14 months since the most intensive media coverage, which really circled around the finding of the children's remains. Since the finding of their remains, I believe at the time the motion was filed, it had been about 28 months. And so we have a significantly larger passage of time from when that media coverage was so intensive and from when the vigils and things were being held here in Fremont County. But we are now only about 6 months away from when that was going on in Ada County. There were crowds at Ada County courthouse steps to hear the reading of the verdict. In addition to that, in Ada County, we had approximately 1,800 jurors that were summoned in. We had approximately 700 that were subjected to voir dire, and which included some of the information regarding the underlying facts of the co-defendant's case, which are also similar to the underlying facts of the defendant's case here today. So we have a significant pool of jurors that have now been sought to talk about the proceedings, whereas in Fremont County, a grand jury was seated quickly and the grand jury proceedings are secret. So any jurors that sat here in Fremont County on this issue have been still ordered not to speak about that, whereas Ada County are now free to discuss that. In addition, when we talk about individuals.
Like there's one thing I do want to bring up here that occurred in Fremont County that I think was probably the pinnacle of media exposure of the whole case. Lori Vallow sentenced here July 31st of this year in this courtroom. And I haven't looked at any objective data, but I would guess that was probably the single most covered event of either of these cases. And that occurred here in Fremont County pretty recently. So,
and I think what we had found on that is Ada County was covering that just as heavily as this area would have been. So I do recognize that occurred here in Fremont County, but it was of daily coverage.
But the event here, I guess you could say, was maybe more than that, because I know people were literally camped out here the day before. They were all around the courthouse for 24 hours before that, and the courtroom was packed to capacity. And I see that if I'm following the logic of your argument, of being pretty problematic as it relates to potential jurors here in Fremont County.
And I can understand the court's concern with that. I guess the state's position would be, when looking at the media coverage and what has been broadcast, the quality and the quantity, what we found is that it was very similar in Ada County. So even though the sentencing occurred here, the media coverage was just as pervasive in Ada County regarding that event occurring here. I do recognize we had a packed courthouse. I recognize there were a few individuals that camped out on the courthouse lawn. I would also indicate during the trial in Ada County, the courtroom most days was packed to capacity. There were some days that it wasn't, but we had an overflow room to allow for individuals to watch the trial. And I do think that was attended at times. Through certain portions of the trial, I think that was pretty packed as well. I didn't go down to look, but I know the courtroom was at capacity for some of the events with that trial, including, I think at a minimum, the closing statements and also the verdict being read there in Ada County. But I do recognize the court's concern with that. I guess the state's position would be that the coverage did not continue, even if it was pervasive, even if that was a highly covered event, it did not continue for months after that. Ada County's interest seems to have been piqued even more so by the trial being held there. We had individuals in public roles in Ada County that gave interviews. The only reason I bring that up is I think oftentimes if it's someone you know, someone that may be a public figure in the area you're from, you may be more likely to hone in on that. Those interviews were conducted there at the courthouse in Ada County. So displaying the courthouse, I think there was note of some vigils being held here at the Fremont County Courthouse years ago. And so again, just looking at that raised some additional concerns and some additional facts that the state thought should be considered at this point in time. And I think, again, just really focusing on the defendant's initial arguments in his motion to change venue. Essentially, it was a motion to change it out of the 7th Judicial District because there was really nothing presented specific to Fremont County. So the state's position is Fremont County does have a smaller population than Ada County, and we absolutely recognize that. But we do believe, given that we were able to see the grand jury, given the passage of time from some of the main events occurring here, and I will give the court, with the exception of the sentencing, the other main events that have occurred here, there's been a longer passage of time from when we had this massive trial. The court had also focused on the media coverage regarding the co-defendant in the initial order for granting the change of venue. That coverage only intensified during the trial there in Ada County. Again, the state does recognize that coverage was here in the 7th Judicial District as well. But again, nothing specific with Fremont County has been presented or located regarding that. We do believe that a fair and impartial jury could be chosen here in Fremont County. I know this matter has been brought up in a motion to reconsider, but of course also factoring in the cost to the county.
Judge, I'm going to object at this point. They didn't bring up the cost specifically in their motion, and quite frankly, I've been quite patient. The fact of the matter is their argument was based literally to the media coverage, and if they're going to be allowed to expand on this, then I want a continuance, and I'm going to go back to every little item, and we'll have to go through this again. So I'm just objecting to this financial argument because they did not make any mention of that.
I thought there was a mention. of it.
There was a brief mention, but I'll just keep it brief. That is all I was going to say really regarding that is what was contained in the motion is obviously some of the factors the court can factor in and consider when determining whether or not a change of venue is appropriate are the costs and things. I think the court addressed that in the prior motion. The state, Fremont and Madison County are cognizant of that issue as well. And so we just bring that to the court's attention also. As an alternative in our motion, we had indicated, again, looking at the population of Fremont County and considering that that may be a concern for the court and a factor because of the pervasive coverage in Ada County, because the defendant opted to request a severance and the co-defendant opted to proceed in Ada County. I think we are now in a different situation. So we would ask the court to reconsider whether or not Ada County is the appropriate change, the appropriate venue, if the change of venue is still determined to be appropriate, given that.
Ms. Blake, do you have I don't know for sure the number. Do you know currently what is the population of Fremont County? I mean,
I should know.
I think it's around 14,000 people.
That sounds about accurate. I don't know when the last census was done. I should have that information, but that sounds accurate, which I do think is a large enough number to pull in 1,800 potential jurors if we were to follow what we did in Ada County.
All right, and I would need to confirm. I had heard at one point from a jury commissioner here that I thought there were around 2,000 qualified jurors total out of Fremont County. And at our last trial, we pulled 1,500 for starters, and that was not a capital case. And we may have to look at additional issues that come up with juror disqualifications with a capital case. Just looking at the numbers there though, but if we're looking at around that 2,000 qualified jurors, and I just note that something I did look into and have to consider, despite the media coverage in Ada County, I mean, it's a whole nother world in terms of population there. They have approximately between 275 and 300,000 qualified jurors out of Ada County. So it's, 100 times, I guess, the amount of potential jury pool there. And I'm just making some commentary here, and I'm not deciding the motion at this point, just making some commentary, but I am fully cognizant of the burden, cost, expense, and concerned about that as well. So I do appreciate you raising that. The court has to take those issues seriously when determining the appropriate venue for the trial in this case. So apologies for my interruptions, but if you have any further argument, you can present that.
That's no apologies necessary. I would just indicate while 1,800 jurors were polled in Ada County, because I know there's a concern we may need to poll more, but only about 700 of those actually were subjected to the voir dire. So I think when we look at numbers, we may not need to go over a mark that Fremont County can easily meet. It's my understanding Fremont County does have a high percentage of juror turnout as well when they are summoned in, higher than some of the surrounding counties. But again, then that's why we bring up the alternative of possibly considering another venue such as Twin Falls, Bonneville County, Bannock County, jurisdictions that have a higher population that would be able to it would be easier for them to meet the juror numbers than Fremont County, but would not have been subjected to such pervasive coverage as Ada County.
All right, well, I appreciate the argument, comments, Ms. Blake.
Thank you.
Let me hear a response now on the state's motion to reconsider the change of venue issue. Mr. Pryor.
Judge, I agree with the court's assessment. My review of the case law was that, at least limited review of the case regard, was that the court, there's no rule or law statute that allows for a motion to reconsider. The court can obviously do that. And in the present day case, the court sua sponte decided to revisit the camera issue. And I appreciate the court's ruling on that issue. And just as a clarification, it was Mr. Daybell's family in Utah and outside of Fremont County that was unable to participate. And given the case ruling, they'll be able to at least watch, and we're thankful for that. This is my concern, Judge, about what they're trying to do here. They're trying to revisit a situation that took a significant amount of time to put together a presentation talking about all of the concerns about having a case in Fremont County. And if the court took the time to revisit its order, there were a number of factors that the court took into consideration. And the court took the time and a length of time to analyze and evaluate what would be the best situation. And one of the concerns, Judge, was the inflammatory nature of what was transpiring in Fremont County at the time. And you talked about it in your order that there was a lot of inflammatory information that was being disseminated out there, and this was of a concern. I had an opportunity to go home and visit my family over the holidays. And I went by a site that 40 years earlier, as a young man in high school, was the scene of a horrific situation regarding one of my very close classmates, the death of that classmate. And that in no way diminishes or minimizes what happened in this case, and that's not the intent here. But Judge, the emotions of seeing that 40 years later brought back the same very harsh feelings, the very same strong feelings, the anger and the resentment. And that event took place 44 years ago. And all it took was me driving by that site, and it brought it all back. And it was a horrific situation. We're talking 14 months. We have a situation where the prosecuting attorney's office at the courthouse in Madison County and Fremont County had all sorts of signs on the courthouse grounds. We had all sorts of publications. The prosecutor can't convince me that the feelings and the anger and the emotion has diminished. And in fact, in many ways, it's getting stirred up again. How's it getting stirred up? The court took some of my information I was going to present, and that Lori Vallow was sentenced. Judge, I heard they were camping outside. They were staying overnight to watch that. My understanding is, and I didn't show up because I wasn't going to be part of the same media circus that she was talking about. But the courthouse was full. And where in this courthouse are they going to cover the overflow crowd that they had during the Lori Vallow trial? Where is that going to take place here? And I think it's highly inappropriate for them to forum shop and say, well, we're not going to have it in Fremont County, but let's pick some of the other counties like Bannock, or let's pick one of the other counties in Idaho Falls, or let's even do Madison County. And unfortunately, the court in its order talked about the religious underpinnings that are part of this case. If we're really going to effectively consider moving this case, and that's really even something that's feasible, less than 120 days before this trial is supposed to start, 120 days. Now, Judge, I've done preparation and I've made plans. And if I'm going to have to change those plans, if we're going to do this, Judge, let's move it. If they're so concerned about pervasive media coverage, let's all go up to Coeur d'Alene. Let's all go up to Grangeville, and let's do that because there's just as much population. In fact, Coeur d'Alene post going on up there. We could move it up there. Let's all of us travel up there for the next 10 weeks and do that, and let's see how that works out. The reality is that was room properly. There were the facilities to handle this. And Judge, for the last 4 times, when is that going to end? When are they going to be done with the construction out here? Are we going to be listening to that during the trial? Because they can tell me and answer that and say, oh yeah, Judge, we've been told that it's going to be done in the next 2 months. But nobody can promise when we're going to stop hearing the drills and the falling and everything else that's been going on during this hearing. But back to the substantial argument, Judge, if you look at the numbers, the court pointed out, and I checked on this, there's a little over 300,000 qualified jurors in Ada County, with a population of in all of Ada County, 750,000 people. So 300,000 qualified jurors. We need less than 1% of the jurors from Ada County to bring in a jury. And if we even took 1%, that would be 3,000 jurors. We have to go back to what the reason for change of venue is. It's to try to find jurors that either haven't heard about this case or haven't formed an opinion, that haven't made a decision regarding this case. And to some extent, you were effective in doing that during the Lori Vallow trial, to some extent. But we only take 1%.